Good morning. The time is 9:45. My name is Christian Waugh. I'm the Citrus County Special Master. I want to start off by apologizing for being late. I was ordered a few days ago to attend a case management conference at 9 a.m. in Flagler County, which I was allowed to attend by Zoom. I did so. Of course, it took 45 minutes instead of the 30 that they said it would take. You had to suffer as a result of that. I do apologize for being late. We have an agenda at these hearings. The first item on the agenda is the call to order. We just did that. The second item is the pledge to the flag, so I'd like to ask you if you join me in the pledge to the flag. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliant Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, so the next item on the agenda is approving the minutes from the November hearing. I have a copy of both the October and the November minutes. Were the October minutes not approved previously? Oh, because they weren't formulated at the time. Okay. Are there any proposed modifications or objections to the October minutes? Hearing and seeing none, they're approved. Are there any objections or proposed modifications to the November hearing minutes? Hearing and seeing none, they are also approved.
Staff update, abated and continued cases are listed out front.
Okay. Just going to sign the minutes. All right, now I had asked for something to be added to the agenda today, and I don't know where that is on the agenda.
It's on the top,
Oh, it's on the
page 3.
CAPA, okay, so if you don't mind, I'd like to just address that first. All right, it's on page 8 of the agenda, and I have a motion from the county to vacate the findings in that case. So the reason why I asked for it to be set for hearing is just so that I could discuss with the county the motion. The basis for the motion is that when I issued the order, actually it was on someone who didn't own the property anymore, correct?
Yes.
Okay.
Yes.
Believe me, you don't have to stand. But is that customary for us? I mean, according to the Citrus County Code, you know, the violation took place all the while they were the owners. I mean, why would I vacate the order?
According to the statute, if the property transfers between the date of the notice of violation and the date of the hearing, the new owner is entitled to
Okay,
have notice of the violation and an opportunity to cure.
okay,
So that's why we did it. The deed, we had no idea about the deed.
No.
okay.
Property appraiser
Right.
hadn't updated.
You
But
found
it
it?
just happened to be the dates.
Okay.
The deed came right before the hearing.
I mean, that's interesting. If that was a way that you could get out of things. But all right, that's okay. I'm going to go ahead and sign the order then. Let me just thank you for drafting it. All right, so that's done. What I want to do before having any other cases called is just read a brief statement for all of you so that you kind of have an understanding of how the hearing is going to run and what your rights are at this hearing. All right, so again, good morning. My name is Christian Waugh. I am the Special Master. I'm a licensed Florida attorney appointed by Citrus County to preside over your hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate your attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation and allow the county to present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will also be your opportunity to present evidence and make any legal argument. It is important that you take your time during this process. because it is likely going to be your only chance to make your case to me. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must be civil, and you must not interrupt other witnesses, parties, or attorneys, including me. In most instances, if you are found guilty of a violation, the law requires that you be given time to comply before a fine begins. Now, you must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or to seek money judgment against you after the lien has been recorded for 3 months. I encourage everyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose the costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs, as well as the cost of the lien imposed. Although it has only happened a few times in my years as special master, I may continue your case if I find the need for further evidence or argument. Are there any appeals of orders to demolish?
Yes.
Ladies and gentlemen, you do have the right to appeal any order I make today as provided by law. Thank you.
First case is on today's agenda, Royal Silverstone LTD, case numbers 218-5826, 218-5827, and 218-5831. Code Officer Brandon Norman, expert on the case, Land Development Director Joanna Coutu, pages 29, 30, and 31 of your agenda.
And for a procedural matter, we would go ahead and dismiss case number 218-5826. Since it's basically moot, it abated.
Okay. All right, then we're only here on case numbers 218-5827 and 218-5831. Correct.
I believe it's 218, the 827.
Is the one we just.
Correct.
Oh, you're sorry.
Correct.
I
Okay.
wrote one and wrote dismiss next to the other, so it is the 5827.
Gotcha. All right. So I've so noted that for the record. We'll only be hearing 218-5826 and 218-5831. Now, why does Royal Silverstone sound familiar to me?
This case you issued, we had a hearing, and at the time, we discussed the fact that the attorney was not here and the clients were not here. They were from the Orlando area. I don't know if you remember that, but anyway,
I don't, but you
Okay.
got to watch out for people from Orlando.
well, I think you might have said that on the record, but
Yeah.
anyway.
For the record, I'm from Orlando, so.
So there was no appearance, no evidence was presented, and you issued your orders. After that, they determined that that they had not been provided notice. They have filed appeals in the Fifth Circuit Appellate Court. And we had, a motion was filed unopposed for relinquishing jurisdiction back to you,
I remember that.
and that's what we're here for.
Okay, I remember that now. I remember signing those orders and being briefed on that. Okay, that makes sense.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Ma'am, can you please state your name for the record?
Yes, I'm Lori Wurtzel on behalf of Royal Silverstone.
Thank you.
Good morning, Ms. Wurtzel. How are
Good
you?
morning. Good. I'm good.
Are you relation to Ben Wurtzel?
Yes,
Oh.
we're married.
Okay, well, I'm a
And he's
fan
my
of-
law partner also.
I believe he was briefly in my courtroom as a prosecutor, so that's interesting. Cool. I like him. I'm a fan, for the record. All right.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is for case number 218-5826 and 218-5831. The property for 218-5826 is going to be address 4474 East Rejoice Street, Inverness, Florida 34453. For 218-5831, the address is 4683 East J Street, Inverness, Florida 34453. Property owners listed for both is Royal Silverstone Ltd. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence.
I
For-
don't know if procedurally we're at that point. I
My,
think we
my
have-
understanding, it was on appeal, and then jurisdiction was relinquished back here.
For the purpose of considering new evidence, newly discovered evidence.
If I may, as Ms. Antrim indicated, the new evidence is really referring to my predecessor counsel who handles the Royal Silverstone's business matters, filed a petition for writ of certiorari in the circuit court. It's actually the improper procedure. But in that, they've outlined a lot of the substantive issues, one of which was lack of notice. They attached what would be considered new evidence that was not before this tribunal. And I later corrected by filing a notice of appeal. Ms. Antrim and I spoke and agreed that it really wasn't appropriate for on appeal to consider things that were not before
Outside the
this
record,
tribunal. Exactly. So we're not really here to argue regarding notice. There was proof of notice. I don't think there was a mistake in that. They just didn't actually have notice. If you would like to hear more about the notice piece and why, I'm prepared to get into that. Or because Ms. Antrim and I also spoke in advance of this, and we're not exactly sure what the scope of what you would want to consider today
Yeah,
was.
I'm not either. So, I mean, I guess what I'm interested in, have you all, I guess I'm not allowed to inquire into that, but I mean,
There are substantive
you
issues.
still want combat on this case?
So there are substantive issues, and I guess there's two categories of them. The one that was dismissed, the reason for that is that my clients were able to cure that violation. So I've listened to the recording of that hearing, which was in June. But essentially, there was no dispute, even though my clients weren't here, from the code enforcement officer, Ms. Antrim, when she spoke, that my clients did not commit these violations, nor did they have nor were they aware of them at the time until they were provided notice. They did receive notice of the actual violations. They were sent to different addresses, so they were aware of that. And so I raised the fact that they've cured the other violation, although that's been dismissed, simply to point out the contrast, which is the two remaining ones are ones that are not possible to cure.
These are the ones where it's like an irreparable.
It was a finite action that had already terminated at the time of the notice of the violation. It was, and so there was a notice of violation provided, and it has the statutory and code-related language that says, here's your opportunity to cure, but the action requested was to stop the action. There was no ongoing action. And so it was an impossibility for them to cure that violation, and that is part of our argument is that it's a legal requirement, both in the code and the statute, and a due process constitutional requirement, given that the purpose of code enforcement is to encourage compliance and not punitive, which is why it's structured the way that it is, that there was nothing that they could do. I spoke with Ms. Antrim about this idea and was told, which I'm sure everyone would be familiar with the idea, that generally what would happen is the corrective action would be to get a permit for whatever work you were doing without a permit. That was mentioned in passing by the code enforcement officer in his presentation and there was no permit obtained. But no one's disputing that my client had nothing to get a permit for because they're not doing any work on the property. And so they actually wouldn't even be able to get a permit because there's no project occurring on their property.
I see what you're saying. And so what you're also saying, I want to make sure I understand what you're saying, is that they weren't responsible for the clearing? Is this a site clearing case? Or tree cutting?
There were trees, yes. That is actually the second part of my argument. The first part is really more just that the county is required to give an opportunity to cure, and they didn't do that because it was an impossibility. There was no possibility. There's no way for my client to cure it, even if they had been responsible for it. The second thing that the special master is raising is an issue that actually I heard earlier in this proceeding and also came up. You asked Ms. Antrim at the last hearing, does it matter that they didn't know? And she responded no, which is consistent with what they've expressed is their position. However, the Land Development Code, which I think is Section 1800 is what she's referring to in that, which does say Essentially, that if you're the property owner or something takes place on your property, you're presumed responsible. But the last sentence says it's a rebuttable presumption, which is required, again, constitutionally, just like a red light camera. You know, you have to have an opportunity to rebut that presumption. It's not strict liability. And even though my client wasn't present and didn't put on a case, the record was rife with what seems to be uncontested allegation that they didn't know and they weren't responsible for it. And that is the evidence that constitutes a
What
rebuttable.
did the record show about that?
The code enforcement officer I guess it's testimony, testified that my client was not aware, did not commit the violation, that they spoke with the attorney, that the attorney indicated that they were not aware of it. There is correspondence that we have, and Ms. Antrim's aware of it because it was filed with that notice of or with the petition for writ between Ms. Antrim and the counsel at that time for my client. When they received the notice of violation, essentially saying, "What is it you want us to stop doing? We're not doing anything." Kind of to my points, and there really was no substantive response. It was just that it's our position that it doesn't matter if you're doing it or if you did it or if you knew about it, that you're responsible. So while I do see where the origin of that is, that's because I would argue that the intent behind that legislatively is that it's not the county's job to find evidence to do an investigation of who's responsible and all of that. But once they're aware and once they believe, and Ms. Antrim said on the record during that hearing, we believe we know who it is.
I remember that.
Because it appeared that there were other hearings that day or perhaps on other dates, and maybe I've also been told subsequent dates.
Well, I remember being curious. I remember when Ms. Antrim said that, and I thought to myself, well, I wonder who that is. I want then, if my understanding of the posture of the case is correct, I want to allow you to put anything you want on the record in terms of argument, evidence, whatever, and we can see if the county objects to any of it. But let's start there.
Yes, so again, I think I've mostly laid out my legal arguments, which would not have been on the record originally. The procedural posture, as has already been said, is that the circuit court acting in its appellate capacity has relinquished jurisdiction to special master for a period of 90 days that began on October 17th. Ms. Antrim and I are required to notify the circuit court of whether or not further appellate action will be necessary. It is our position and our request to ask that these be vacated, these remaining two cases, based on my arguments. They're based on due process and also the language of the code. And that if that were to be the result, then certainly we would dismiss our appeal and notify the circuit court of same, because it would be moot at that point. And if not, then we would just proceed with this as a supplement to the record.
I have two questions for you. First, do you have any additional evidence, or are we here for any additional evidence?
The newly discovered evidence, again, was really referring to, there were credit card statements and certain things to establish that my clients did not have actual notice of this hearing.
But that's probably not disputed. I mean, does the county dispute that there was no actual notice?
As opposed to legal notice.
All we have is the return receipts, and they presented evidence documentation in the appeal or the petition for cert indicating that the person who would have been signing that was not in Florida at the time.
Okay.
The notice of the violation was sent to the registered agent, which was their attorney, which is how they got into touch. The notice of hearing was sent to the tax collector's address, which both are authorized under statute for notice. So again, that's why I'm not legally contesting that.
Okay.
But because they were sent to two different addresses for whatever reason, then my client truly had no notice. That's why I said at the outset that if it was relevant, I don't believe, my impression is that the county attorney has an objection to you rehearing these arguments, because that's why we're here. It was unopposed motions. But
so the second question I have is what is the basis for what you're asking for me to do? I know you're asking me to vacate. What is the exact basis?
So I guess procedurally speaking, from a technical aspect, and maybe to some degree, it would matter, particularly as a practical matter, how much the county objects to any part of this. But the basis for the motion to vacate really would be the notice issue and the lack of actual notice, which is the newly discovered evidence that was not before the special master. I presume that if the special master was aware at the time of the original hearing that my client did not have notice and was not aware of the hearing, would have probably continued to allow them an opportunity to appear. Or maybe not, but
If there had been a request made, I would have.
Correct.
The issue is if you're right, or if I validated your argument, it would put the legal notice that the county and every other county and city basically functions off of for these types of cases into question. In other words, if I'm to find that that's not sufficient notice, I mean, that blows up the whole statute, frankly, but what's interesting to me and what you're saying is this part of 1800 about the rebuttable presumption and the fact that the county may have said that they know that it's someone else.
well, and that's what I'm saying in terms of the degree to which the county attorney objects. I think as a procedural matter, technically, I'm appellate counsel. So I am used to being stuck in the procedural. And so in that sense, I do believe that technically, if the other party was objecting, that you would have to find a basis to vacate, probably based on notice or newly discovered evidence, and then could have a rehearing, at which time you could consider these arguments. I do believe that most likely, just in an equitable sense, that it would also be fair, assuming there was no objection to the procedural requirements, that now that these new arguments, are not new evidence really, have come to your awareness and to the county's awareness, that could be an equitable ground to vacate the original orders. That being said,
Do I function in equity? I mean, do I have equitable powers?
that's why I am emphasizing whether or not the county objects. But I will say that in terms of the notice issue, to get back to the technicality, the reason why I'm not focused on the legality of the sufficiency of the notice has already been stated. But it's really a USPS issue, and I can't fully explain, but it was delivered to a PO box. Technically, you're not supposed to really be able to do a signed notice to a USPS PO box, first of all. It's clear from the record it was a PO box. It appears, but from my investigation, it appears that there is a signature that USPS keeps on file electronically and pastes every time they accept something for this business at the PO box, and then they have him sign something when he actually comes to get it.
That's hard when you're appellate counsel and you have to try and fix the record that you receive.
Correct. And so the only evidence that my client could produce, other than I could produce him if I had to say I didn't. The person, Mr. Medlin, who is the one that's demonstrated on the signature, that was why the credit card statements were produced, which is what Ms. Antrim referred to. I do have them. They were not part of the record in this case. They were filed with that original petition for writ. Demonstrate that it's Mr. Medlin's credit card statement, and it just demonstrates that during the range of dates where he supposedly signed, which was May 22nd, that all of his charges the days before and after are in Indianapolis.
Yeah, I mean, okay, I want to make sure you're able to put everything you want on the record. I'm not sure I'm going to rule right now.
Sure, and so the basis of the motion to vacate regarding the notice would not be that the notice was insufficient, but rather that there's new evidence before the tribunal that notice was not received actually. And so in the interest of due process and in consideration of that new evidence, that could be the basis of the motion to vacate.
Does the county object to the credit card records being a part of the evidentiary record?
No, I do not. And I believe that's what we're here for today, for you to consider that evidence and determine whether or not that was actually his signature or whether he was able to have signed for it at the time. Because that's where the issue is. The code enforcement office went through the proper procedure, mailed it to the proper place.
Yeah.
However, if he really didn't sign for it, then we have an issue. I do want to address the issue about whether we were to provide an opportunity to correct the violation. And under the statute, the code enforcement does not have to provide a person with a reasonable time to correct the violation if the violation is irreparable or irreversible. And that is section 162.21, subsection 3B.
Which you've
And in this case,
incorporated.
it was irreparable. There was nothing that could be done to fix it.
This is kind of a matter of first impression for me, so I'm not prepared to issue a ruling today, to be honest. Now, that may affect your jurisdictional issue with the circuit court, but what I would say is I have some concerns about, even if we incorporate, and I'll accept the credit card records, we'll make it an additional exhibit, but even if I did that, I don't have any, to say it's hearsay evidence is generous, especially without someone to authenticate or to explain that they were there under oath, to say that they used the credit cards. Is there an affidavit or is there something? Do you get what I'm getting at, Ms. Wurzel?
I do. I think under the statute and the code, the rules of evidence do not apply here.
Well, actually, so you're right. As a technical matter, the rules of evidence don't apply. However, I'm not able, what the law does say is I can't make findings of fact on material issues solely based on hearsay. So I don't, it may be that it's enough to raise a burden or something like that, but it's just a credit card record to me without something more. What I'm getting at is if y'all really wanted to do this and go down this road, I suspect, and I'm not issuing a ruling today, but I suspect that credit card records are not going to be enough. I suspect that for my purposes, I would want to hear testimony.
And that, I mean, that's part of why, as I said, the initial scope, and that's part of why I reached out to Ms. Antrim, and she didn't know either, to anticipate what to anticipate
Yeah,
today.
There's no way that, but that's why I'm not saying, I mean, if y'all want
And
it,
so
you
we're
could
happy to
continue.
produce whether it's an affidavit or,
I think they need to be subject to cross.
okay.
And whether it's my cross or the county's cross, because I feel like the door's open. If they're willing to have the credit card records, then I feel like they should also be willing to allow corroboration of what these records mean. Does anyone else have access to these credit cards? You know, that kind of thing. Could they have been electronic charges? Were they made in person? The records may show that, but I don't think records are going to be sufficient for me to overturn the order. So if y'all want, I could set it for an actual evidentiary hearing, but you'd need extra jurisdiction for that.
In terms of the jurisdiction, I think generally speaking, I mean, part of why this took so long is it took us a while to get the orders from the circuit court.
Oh, I know.
But the only obligation is for us to provide a status report. If I could do that, today and ask for more time, theoretically, I think we'd probably be fine. And ultimately, if not, then I have to file my brief.
I don't know why they would care. To
I
be
don't
honest,
think
but
that they would. So I'm not concerned about that because I know I can cover all of my bases on that. And my worst case scenario is I have to file a brief and, but in that sense, I think that it's likely, worth it to my client hearing, this is our first opportunity to really address these issues, hearing what is important to the tribunal is important to us.
I'm not making promises. I'm
Of
just
course.
saying I'm willing to hear the testimony.
Of course.
Would you consider then setting a hearing for the evidence to be produced, and maybe even a hearing that's not on a regular code enforcement day?
Yeah, if that's what y'all would like. I
And
mean, I
would
can-
that hearing be not only evidentiary, but would we be able to present any legal argument at that point as well?
I don't think I can stop you. I think due process requires, I don't mean, what I mean is I think due process probably requires that. I'm not gonna shut down, but how much time do you think you all would need for this?
Honestly, it's not an issue of time. I think I've fairly made most of the arguments. I just want for us to be prepared for what the intention is to address it.
I can issue a briefing order and just say, okay, we're gonna continue. I will allow evidence on this date, whatever works for the county and for respondent. What would you have in mind, Ms. Antrim, in
Well,
terms of?
you'd be providing the testimony.
Yes, I mean, that should probably be brief.
So however much time that would take.
An hour?
I think that would be fine. It's a fairly limited set of issues for the evidence.
Let's set it for an hour. And I'd rather set it now if possible, but when are y'all?
Is February 13th okay, or?
And I'm just checking my calendar. I think that will be okay. February 13th.
We're fine.
Okay. Yes, that should work fine. In the morning, first
Yeah.
thing.
Mhm.
Would 8:30 be okay?
That's fine.
8:30?
Yes, it's.
Okay.
And then I think even though we talked about it and you said that you would accept it, I'll hold off on the credit card records or anything so they can be properly authenticated.
What
And
we'll do is I won't admit them until the hearing, and so you can, like you just said, authenticate them, introduce them the proper way.
thank you so
Okay.
much.
All right. So anything else from the county? I'm sorry. Didn't hear. Is there anything else from the county?
I have nothing to.
Okay. Thank you.
you.
Thank you.
Next case on today's agenda,
Actually, I apologize. Is there anyone from the public who wants to be heard on those cases? All right. Now we're done.
thank
Thanks.
you. Next case on today's agenda, John R. and Judy LaPuma. Case number 2023-883, Code Officer Alan Jonason, page 21 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Sir, can you please state your name?
Yes, Chris Blaisdell. I'm an attorney for Judy LaPuma.
Hi. Good to see you.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-00883, General Commercial District. No new general commercial district shall be allowed in the coastal lakes and river region. Citrus County Land Development Code Section 2412 of the Citrus County Code of Ordinances. Address is 30 North Florida Avenue, Inverness, Florida. Property owner is LaPuma John R. and LaPuma Judy. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 28 September 2023. Photos from a compliance inspection on 13 November 2023. Photos of my final inspection conducted on 19 December 2023. And an aerial photo taken from the property appraiser dated 20 July 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, a copy of the pre-hearing notice, and a copy from the property appraiser's website.
Okay. Sir, normally what we do is I ask respondent to take a look at the proposed evidence
Sure.
and let me know if you have any objection to it.
Yeah, that's from July 20. Okay.
No objection.
Okay, thank you. Thank you. Without objection, what's been proposed as Exhibits A and B are admitted as evidence.
On 28 September 2023, I conducted my initial inspection and observed the property to be in violation. On 28 September 2023, a notice of violation was issued for General Commercial District, which is a violation of the ordinance mentioned earlier. On 13 November 2023, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, and as of my final inspection on 19 December 2023, the property remains in violation. Land Development Director Joanna Katu is the expert on the case.
Good morning.
Good morning. This is a site for general commercial. There's no disputing that. Tire sales and auto repair are absolutely permitted uses there. We're aware of that. And what they've done is store tires outside of the building, outdoor sales and outdoor retail, outdoor storage. There's special requirements for that. I can see recently they put up a fence to try to screen some of the tires. That's one of the absolute requirements of a permit. So they're well on their way, but I can see on the aerials, these were not on the 2019 aerials. They showed up in 2021. So it's a relatively new addition to the site.
So what exactly is the violation? It's selling
The
tires?
outdoor storage and sales of tires.
Outdoor
Right.
storage and sale of tires.
Right.
And so what I'm trying to do is square it with the code. So this
Mm-hmm.
is under 2412. Before I turn to Mr. Blaisdell, I always like to
No
make sure I
problem.
understand your case. Where in this section does it prevent that?
So it talks about outdoor storage. They're not getting a primary use of outdoor storage. They do have the auto repair, sales and service, and you'll see that in GNC.
I'm in GNC.
Right. So in GNC, those uses are allowed, but not outdoor storage. You'll see that as well, you might not have a current code, but it is a PUD. It is a PUD requirement generally as a primary use. I don't think it's going to be their primary intended use. I think this is secondary to the auto repair. The non-residential.
Well, now
Go ahead.
I work at the pace essentially of a kindergartner when I go through this code section. So
Sorry.
where is it in the section that auto sales and all that are permitted uses? Or PUD? You said PUD?
Yeah. Can I approach? Is that
If
right?
you could,
Sorry.
yeah. I'm sorry.
Page 26 under other.
I'm
That's
in
where I'm
other
finding it.
and,
Right, and it's listed, I get that, right there. It says
okay, sales,
repair of motor vehicles is a key.
rental, service, repair. Okay.
And we've got an older one.
I don't see any PUD, or I see some PUDs.
Right.
Is this a PUD? Is it?
It's not.
Oh.
It's not. It's general commercial. So we have RV and boat parking and outdoor storage somewhere. You have an older version. I apologize for that, but
It says,
yeah.
Can you talk into a microphone, Joanna?
I'm sorry.
So that council can hear you?
Yeah.
Sure.
Sorry.
Oh, no, you can.
she's just leading me through this code section. She's saying that I don't have a current version of the code in front of me, which
Right. So
It's unfortunate.
We'll try to get you that too. But you'll see that outdoor storage and sales is not listed. It's not a primary use there. It was recently added as a possible for GNC and a PUD, which it's not. This is not a PUD. I don't think that's his primary use. I think the primary use is absolutely for the site auto repair.
could they get a PUD?
They could. That would be one way to fix this. The other would be to go through the permitting requirements. We have a section in our small non-residential standards that deals with outdoor sales and service. And the screening that they put up recently is one of the big parts of that. So they're on their way.
Is there's a reason why I'm going to ask this, but in anywhere in these zonings, is it permitted to have outdoor sales?
Yes, you'll see it in industrial zones.
So the county does have an intention to make explicit where it's allowed and where it's not.
Correct. And then industrial allows it. General commercial with a PUD perhaps.
Interesting.
But they can, like I said, on their way, they can make it accessory to the current use if they want to permit it that way. Screening is part of that requirement.
Are car dealerships, do they just get an extra permit? Are they industrial?
When car dealerships come in, the cars are actually part of the permit as to where they're going to park them and sell them.
Okay,
Yeah.
I think I understand the county's case. What's going on?
Yes, sir. So I do have some pictures that were taken on Friday,
Okay.
on the 15th.
Yeah.
I can authenticate them with the owner of the tire shop. He's here today, Christopher Gordon. However, if you want me to
They
stop
were
right
taken
now.
on December 15th.
Yes, sir.
And have you seen the December 19th photos?
I have. These actually show some parts of the shop that those do not. So like.
Okay, well, I want you to present your case. I guess before we get to that, I guess I'm wondering, is it going to be your case that there is no violation?
Either no or a minimal violation that could be easily corrected. So to the extent that you're gonna make a finding
Yeah.
as to what needs to be
No,
done,
okay.
this might
Sounds
aid you
good.
in
Yeah, I'm
that.
happy to. Have you shown the photos to the
I'm
county?
about to do that right
Why
now.
don't you do that? They may not object, and I don't need authentication per se if they don't object. Is this your only copy, by the way?
Yes, sir.
Okay,
Although, yeah,
okay.
we can get others, but for today, yes.
Because I, obviously, once they're in evidence, they're
Sure.
mine.
No, I'm sure Mr. Gordon could get more if he needs to.
Well, sometimes people only have stuff on their phone, and I'm loath to take their phones.
Sure.
You know.
That could be a problem.
No, it's the top, I think the tires are in there. I think that's their temple screen.
The fence looks good. Is there any objection from the county?
No objection.
Okay, then I'll admit these as Exhibit C. And if you want them and you want to talk to me about what they are,
I can,
You'll
I'm
lead me
prepared to
through it,
address
okay.
them anyway.
Yeah.
They're not too complex.
sounds good. So first of all, you'll represent, these were taken on December 15th.
Yes, sir.
Okay.
And Mr. Gordon can testify to that if necessary.
Now, tell me about them.
So what that shows, in addition to also showing the fence, which I think you can see that from more angles and exactly how it looks from the road, you can also see that compared with the aerial photograph that was taken previously, the tires that are in the back of the shop are now covered. So frankly, I'm not sure if that qualifies as a structure under the code. That's a little ambiguous, but it certainly is more compliant, let's say, than it was before when those aerial photos were taken.
Yeah, so I mean, these photos seem to, what I am taking away from them is there are some tires that are outside of a structure, but they're on a rack of some kind, which is right next to the building. And it appears that the fence, or there is a fence blocking most of the view of those, and then I don't see any others that would be visible or outside.
Yes, sir.
Okay.
That's what we intend to present.
And then if I look at the county, I'm gonna try and square all this. The photos from the 19th, they are consistent with the December 15th photos. I don't see any real daylight between them. Obviously, the overhead, well, gosh, that's interesting. It says the overhead was last updated December 12th, 2023, which would be before. I mean, I guess a lot of work was done between the 12th and the 15th. Or no, this was July
that was
20th.
July.
This is
Right.
July
July,
20th, my
yeah.
bad.
I was gonna say, I
So I
figured
thought-
that was
Okay. Is it the county's position that if the fence, I mean, is this still outdoor sales?
Sales perhaps not, storage definitely. I'm happy to see the rear covers because that tires we worry about with mosquito breeding with waters in them. However, the covers also create impervious surface, which creates stormwater issues. So that would have come up on a permit for the outdoor storage wherever they want to put it. I can't verify whether they're actually selling the ones in the back or just storing them, but that is a concern. I appreciate that they're covering them, but it raises other questions. So they can permit this on the site. There are ways to do it. But unfortunately, just covering it out of sight doesn't really make it there.
Here's what I'll say about the outdoor stuff. I think for the purposes of this case, it's not the creation of impervious that matters, but I think the point is well taken that if the cover wasn't there, if it was just under the tarp part of the tent and the curtain wasn't there, it would obviously still be outdoors. In other words, these are temporary, these look like temporary structures. The orange, I'm talking about the orange
Yes, sir.
tents. They're not permanent structures. So it's like, that is outdoor. Anyone could still walk in, whether you have a curtain or not. It's not a curtain that determines whether it's outdoor or not. I think I'm not concerned with the fact that it creates impervious, because I think that's a separate violation perhaps, but that's not.
Yeah, understood.
I guess I see the county's point. I mean, but at the same time, obviously y'all have made good faith efforts. Is what I'm saying making sense for what would have to be done in order to bring this into compliance?
It is. I guess you're saying there would need to be a more permanent structure in order to.
Yeah,
bring it into
because
compliance.
without a permanent structure, if it's just a temporary structure, there's really no difference between it being out. I mean, if I am living under a tent, I'm outside, right?
Sure.
I mean, if I'm in that tent, I'm living outside. No one would say I'm living inside.
Mm-hmm.
Does that make sense?
Yes, or the alternative would be as was pointed out, to get a permit for the storage.
Heaven forbid. So these are options.
Right.
And the reason why I'm bringing this up is, how much time do y'all think you would need in order to either get the permit or get this stuff inside?
If I could have a moment.
Yeah, sure, absolutely.
Okay. So my understanding, sir, is that the tenant was not able to get a permit for a permanent structure outdoors there. So that's apparently an impossibility.
Okay.
Um,
Let me ask the county, are you aware of any applications for permit?
No, and I could help your client with that. Absolutely.
right.
There's not a provision as long as that's not the primary use.
So you're not aware of any reason why a permit would not be possible?
Correct.
Okay.
the-
Yeah, well, first tenants can't get permits, and anything permanent would
Oh.
have to also
A
be
tenant
set.
can get a
I'm not
tenant
talking
can
about
get a-
that. I
She's talking
apologize.
about
I'm looking at
outdoor
land development
storage.
code.
Oh, okay, sorry.
I'm not
Right.
talking about procedurally who owns what, I'm sorry.
Yeah.
Well, can't the tenant get a permit if they have authorization from the owner?
There are
The-
other steps, yes, but
Okay.
just if they walk in by themselves, they cannot.
My understanding with that is that it's cost prohibitive for my clients, but I understand that's
Okay.
not necessarily a.
Interesting,
Yeah.
okay, okay.
Um,
So it's then we've established, fine.
I will say that there was also contact with the EPA, that they looked into this and cleared it, and the state has also cleared it.
The EPA.
So to the extent that that matters, I realize it's a completely different code for the
Yeah, I
county.
mean, I
so-
really don't think that the land development code is on the EPA's radar.
Understood.
I'm skeptical that anything, I don't know what's on their radar. these days.
I've seen the emails. My client has had contact with.
I
them.
think that's cool.
So,
I think that's interesting.
but obviously their thumbs
It's a
up.
dangerous game.
Yeah, their
playing
thumbs
with
up does not clear it with the county. So,
What I think is required of me is to give a reasonable amount of time to find a way to fix this, you know?
yes, sir.
And so that's either bringing everything inside, I think, selling from the inside, not having outdoor sales and storage, finding a way to get storage, whether permitted or somewhere else off-site. But it's got to be something that brings it into compliance. So if I don't have a time period, I'm going to give one, you know? So do you have any suggestions? 60 days, 90 days?
What is considered outdoor sales? Because we mount
I-
balance tires, I sell about 400 tires.
If I understand
And
what
I do it by Jackson, we don't have
Right.
lifts.
if I understand what you're saying, either a permit would have to be acquired so that the tires can be where they are right now, or a structure would have to be built that was permanent where the tires could be stored, or the tires are gonna have to be moved from where they are now to a different
Or
site.
it becomes a PUD with a contract with the county to allow it.
Right.
Which you've heard is possible. It's theoretically possible. There's no guarantees of work. It probably would take time and money, and you get attorneys involved, and
Yes.
Whether they're bargains or not, it's not free. Well, look, the question was asked, what is an outdoor sale? And what is an outdoor sale from the county's perspective? Is it items that are stored outside and sold outside? Is it people standing outside and selling something that's inside?
Ooh, yeah, I guess it would be both. Yeah, I mean, we haven't had it questions. Outdoor is outdoor. I know this is going to take some time. If they do like a pole barn or something, even those take some time to get the engineering and get permitted. So I think more time is probably better, unfortunately. They've done a lot of cleanup in the front. I'm happy about that.
All right. Is there anything else? All right, then what's the county's recommendation?
Excuse me. Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
And I just, about time. Would 6 months be unreasonable?
So here's what I'll do. I'll find that the property is in violation, and I will grant 6 months to bring the property into compliance based on respondent's request, as well as the fact that I don't have any, actually, first, is there anyone from the public who wants to be heard on this? Okay. I don't have any pressing, I think, sanitary concerns, which would normally require a quicker time for compliance. Y'all have tried to make some improvements and have made some improvements. And if it's not brought into compliance as ordered, $100 per day.
Understood.
Okay?
Thank you.
Thank you.
Thanks, sir.
Thanks, Joanna.
Next two cases on the agenda, Chase Neil Jones and Callie Sheila Wallace, case numbers 2023-746 and 2023-1095. Code Officer Amy Becker, pages 19 and 20 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names for the record?
Chase Jones.
Callie Wallace.
Thank you.
Good morning.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Division. Okay. Case number 2023-746, abandoned, unserviceable, unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41, and case number 23-1095, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address for both is 9384 North Citrus Springs Boulevard, Citrus Springs, Florida. The property owners are Chase Neil Jones and Kayla Sheila Wallace. I have good service via posting of the property as well as the Lecanto Government Complex for both. I would like to authenticate the following documents and request that they be admitted to evidence for both cases. Exhibit A. Photos taken during my initial inspection on October 25th, 2023. Photos taken on November 7th, 2023 at my corrective action inspection. Photos taken on December 7th, 2023 showing the posting of the property. And photos taken on my final inspection on December 19th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing for both and pre-hearing order, and a copy of the posting affidavit for both cases.
All right, ma'am and sir, I'd like to ask you to take a look at these documents, and it's going to be an Exhibit A and B for each case. Let me know if you have any objections to them being evidence,
Absolutely.
and take your time.
This is the junk.
I do have a question. One of the pictures of the accumulated junk, I was getting a bunch of donations for my job at my retirement home. It's bags of clothes. They're at my retirement home now. It was just people dropping them off, and I worked 7 days a week. So I just didn't know what I'd do about that.
We'll talk about it.
Okay, 10-4. Okay. You're welcome.
So I understand, and we'll get into that you want to talk about the photos and the evidence, but do you have any objections to these being evidence in the hearing?
Oh, no.
Okay, all right. And just so I know ahead of time, is there anyone from the public who wants to be heard on this case or either of these cases? All right, thank you. You know, unlike Orange County, the Citrus County attorneys look at the evidence. It's very interesting. All right, so without objection, what's been proposed as exhibits A and B in each case are admitted as evidence. Please proceed.
Thank you. So on August 24th, 2023, I conducted my initial inspection for abandoned, unserviceable, and unlicensed vehicles and observed 2 vehicles, one with an expired tag and another that appeared inoperable, which is a clear violation of the ordinance listed above. On October 25th, I've spoken obviously with the owners of the property. And to make this brief, because we have a lot of cases, there's been major progress. As far as the junkyard conditions, there's been major progress. So the only thing that's left is a couple auto parts. And then as far as the vehicles, they both remain with expired tags. In a nutshell, that's it.
Okay. Let's talk about the vehicles first. I feel like that's easier. What's y'all's plan?
So the red Nissan in the front, that will be scrapped this weekend. I was trying to sell it, but I mean, the way the economy is, nobody really is trying to buy cars. The black Miata that's now in my carport, it runs. I just in the process now of chopping out the transmission. I did blow that. So that's the new photos that you've seen with a cherry picker and all that. So I just swapped the transmission and all that out. But that was my daily driver, and it will be again here next week or so.
So what you're saying is the Miata will become serviceable.
Yeah.
Okay.
It ran when she first showed up.
Okay.
I offered to start it. It just wouldn't move anymore because I blew the transmission up. So
Okay, well, so what I guess I take your testimony to mean is you don't need that much time in order for it to become operable.
no, not really.
What do you need to see in order to determine that it's operable? Do you need to see it move? Do you have the right to see it?
I usually these people have been fantastic to work with.
Yeah.
I would take their word for it if it was tagged.
Okay.
So I've got 2 expired tags, which
Yeah.
would mean that.
I mean, that's the issue with the tags, they've got to be, okay. How much time do you need to fix this? I mean, I heard what you said on the red vehicle. Is 30 days enough to resolve that?
That'll
Okay.
be fine.
And on the junkyard conditions case, actually, let me just look through the photos to see.
The 2 transmissions are in one of the photos. One is the old one, the new one just went in.
Yeah, I mean, it's, what's the junkyard condition?
The junkyard condition on the last picture would be the auto parts in the front, and there's also a trash bag in the back. I can show that to you if you need to see it on the last picture.
Trash bags.
And then there's two auto parts. There's a filter on the left side. And then there's, I guess it's a carburetor. I mean, I don't know.
Oh, my
It's
radiator.
the
Radiator's up
radiator.
against those handrails. which I
So
do,
it's the auto.
What's the radiator there for?
The radiator came out of the car when I was pulling the motor out to swap everything and freshen up the motor.
So it's a part of the Miata.
Yeah, it's part of the car. That's going back in. The handrails and stuff that's up there. I do my own side welding. I will welding business, so use that as all my.
Does this
material.
stuff have to go back in order for the car to become operable?
Yes, which that's we worked on today. The radiator and all that we in today, and actually, really, I should be able to start the car today.
Don't jinx it. Sorry.
Somehow it goes.
That's right. That's right. I'm just gonna look at the definition. So the definition of junk actually includes used or unserviceable automobile or machinery parts. And I think what you're saying is they are serviceable.
Yes.
Um,
Like that red Nissan, it runs. It just needs a part of the transmission. I mean, I can still drive down the road.
well, what
it
I mean
just
is the
works.
radiator is serviceable.
Oh yeah.
Oh, yeah.
The how long have those garbage bags been out there?
They're not even there.
They're not there.
No, they're at the retirement home now.
Well, we have garbage from Thursday that needs to be taken,
Oh,
but
yeah.
Okay, so would you be able to fix whatever remaining issues there are within 30 days?
Oh yeah. And the garbage gets taken out tomorrow, so all those bags will
Okay,
be.
what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, case 23-746 and case 23-1095, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
What I'm gonna do is I will find that the property's in violation. But I'm gonna grant you 30 days from today to abate both of the violations, okay?
I see junk in the car.
Now, if they're not brought into compliance within 30 days, then it'll be a $50 fine per day,
That's
okay?
okay.
It sounds like this is enough time, and it's just really important that you keep in touch with Ms. Becker to let her know when everything's done, because she'll
We
let
have
you
a
know
card
if
and
it's not,
everything. Yeah.
okay? All right, that's it. Thanks.
thank you.
Next case on today's agenda, Anthony and Lisa Fioretto, case number 219-9591. License and Compliance Officer Timothy Williams, page 15 of your agenda, expert on the case Samuel Acosta, Building Director.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record.
My name's Brenda McKenzie. I'm with McKenzie Permitting and Consulting. My office is at 7232 East Gospel Island Road in Inverness. And I'm here for my clients to
Okay.
give an update.
Thank you, ma'am.
Good morning. I'm
morning.
Timothy Williams, Citrus County License Compliance Officer. This is case number 219-9591, Chapter 18, Article 1, Section 18-8A. Obtain after-the-fact permits for all construction or modification of the Citrus County Code of Ordinances. The address is 9136 East Devil's Neck Road, Floral City, Florida, 34436. Property owner, Anthony and Lisa Fioretto. Had good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, Photos taken from the initial inspection on July 12th, 2023. Photos taken at the corrective action inspection on October 1st, October 31st, 2023. And photos taken at my final inspection on December 19th, 2023. And photos from the property appraiser site of 12 of 2018. And Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail receipt indicating good service.
And Your Honor, we would inquire if the owner is here or if she has a power of attorney to represent, otherwise she'd just be a member of the public.
Well, I mean, so Ms. McKenzie, I guess it is Ms. McKenzie, right?
It is.
Okay.
Correct.
Can you tell us a little bit about your role? Do you have a power of attorney?
I do not. I have an authorized agent form is what I usually use when I'm
Okay.
doing variances or CPA, AAs, or
And it's
going to-
signed by the owner?
signed by the owner and notarized by Jennifer Griffin, who works here at the Citrus County Building Department.
Could I see a copy of it?
Yes, sir.
Sounds like, I appreciate it. And I'll let the county take a look at it. It looks like it's actually a Citrus County form. Okay. Authorization, code enforcement. Looks good to me. I'm satisfied, but you may want to show it to the county.
Our only argument is that that wouldn't apply to this. It's for making applications, which we completely understand, but for purposes of presenting evidence for this hearing, we do not believe that qualifies her.
Okay.
Do you want me to speak on
Oh, no, I'm
later
going to
as-
allow you to
as
speak.
public?
No, I
Okay.
find it sufficient. So,
Okay.
let's, and the reason is that it's notarized, okay?
Yes, sir.
Now, there are times where, actually, let me think about this.
And we would request you put it into the record if you're making a finding based on.
No, I mean, I have to think about it because recently we had a power of attorney form that was signed, but it wasn't witnessed. I didn't allow it. But this does specifically say for code enforcement, it's a form created by the county. And I don't know that they would have any reason to know that it wouldn't apply because it does say code enforcement. In fact, I don't see what other reason it could be for since it says code enforcement. You don't send applications to code enforcement. So, all right, could you show these documents to Ms. McKenzie? Ms. McKenzie, I'm going to just ask you. I know you're not the owner, but the county has an objection to your standing. But do you have any objections to the documents that Mr. Williams is showing you?
I don't, and I've.
You've been in contact.
Yes.
Okay.
yes. Mhm. And Mr. and Mrs. Fiora have also, they just don't live here locally.
Okay. Thank you. By the way, is there anyone from the public who wants to be heard on this case? All right. All right, please proceed, Mr. Williams.
Thank you. On July 12th, 2023, an inspection was conducted at 9136 East Devil's Neck Road, and photos were taken regarding construction without a permit. During my inspection and after research, I observed renovations of a sliding glass door to a window on the front of the home and an enclosed back patio. A notice of violation was issued for an after-the-fact permit at my correction action inspection on October 31st and my final inspection on December 19th of 2023. The property remains the same and without a permit.
What's the violation? I mean, what did they do? It's a sliding glass.
Construction, a window got changed, a sliding glass door got changed to a window,
Okay,
and they enclosed the back porch,
and they enclosed the back porch. Okay.
back lanai.
All right. So, Ms. McKenzie, what's going on?
So good morning again.
Morning.
Just to let you know, he's contacted me. These things were done. He thought that they were non-structural. It was a slider to a window and thought headers were there. In any event, we have hired Keegan Jablonskis with KJM Drafting. We've gotten plans drawn. We had to do a site visit to do an as-built drawing to get blueprints. Michael Wilburn with a local engineering firm has reviewed those plans and sealed them. I have submitted them for a building permit number BLD 2023-27517, which was just done a couple of days ago because we didn't have the paperwork to do so. And I would just like to give a little bit of time for that to get through the permitting process, and his intentions are to comply.
How much time do you need?
I don't really know how to
Yeah,
answer.
one never knows.
Yeah, reasonably, I would think by the end of January, Christmas is in here. But, I do want to let you know we have applied and there is a permit number of record.
Does the county disagree with anything that it's heard? No, sir. Okay. Does it have any immediate safety concerns? I mean, I know there's a presumption, but, do you have any, in other words, sometimes when there's an unpermitted structure or something like that, you may have a concern that it's about to fall down. Do you have those concerns here?
I do not, no, sir.
Okay. So would 60 days, do you think, be enough?
I think that would be generous. Yes, thank you.
Really? Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully request that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the action of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order for allow for reinspection.
Okay. I will find that the property is in violation. I'll grant 60 days from the date, from today to abate the violation. If it's not brought into compliance as ordered, a fine of $50 per day will be assessed. I think that's it. Oh, is there anyone from the public who wants to be heard on this case?
The county attorney would like to be heard for a second?
Yeah, of course.
We would request that the document that she presented be brought into evidence as Exhibit C, please. And just note for the record that under 19-54 sub H, the party is only supposed to be represented by an attorney or by the party, and that the form she has and is hopefully coming into evidence, code enforcement was typed in. It's not a pre-filled out portion that is allowable on that form that the county represents. So the county cannot present whether or not she's the one that typed it in, and it's not something that is presumed to have been, that form is to be used for, just for the record.
Ms. McKenzie, who typed it in?
I typed it in.
Okay. All right, so I'm looking at 19-54.
Under other, I typed it in under other.
No, I mean, that
Okay.
I understand. All testimony shall be given under oath, shall be recorded. Is your client here?
No, sir.
Did they ask you to be here today?
Yes, sir.
Okay.
I could have spoke as just someone from the public. I didn't
Right.
know when I was supposed to come up.
In 19-54, here's, I guess, what I'll put on the record. It says each party shall have the right to be represented by an attorney at its own expense. It says that you have a right to it. I guess you could suggest that a party doesn't have a right to be represented by anyone else. But I think there are other sections that might speak to this, but I don't find that this section speaks to that issue. So, do you have a copy? Is that a copy you're willing to put into evidence?
Sure.
That's fine. Maybe the county will appeal the order. That's okay. Just, I mean, and for the record in the future,
Okay.
I have in the past excluded powers of attorney that weren't properly witnessed and notarized.
Okay.
Because there's a Florida statute that talks about what it takes for something to be valid. The reason why I have accepted this is because it is signed by the owner, notarized, so it, and also it seems to be a county form where its intended use was for code enforcement. I can't construe any other reason why it would be signed unless it was for you to represent them here.
Yeah, and I've done it for, like I said, PUD, Planning Development, Board of County
Yeah.
Commissioners, things like that.
Well, now you're
I
on
didn't real-
notice.
So be power of
The
attorney.
county does not accept
Okay.
it for this.
Okay, so
you have to
noted.
rely on my grace,
Yes,
which
sir.
is
I guess I could have spoke as public rep. I'm sorry.
no, it's okay.
Okay.
No, but you don't have to apologize. I'm just warning you. This is a way you can surmount that issue in
Okay.
the future.
I appreciate that.
Anything else from the county?
We're good.
Okay, all right.
Thank you.
So
Okay.
this is Exhibit C, and I'm admitting A and B.
All right,
Thank
thank
you.
you and Merry Christmas.
Merry Christmas.
Thank you.
Next case on today's agenda, Leona Forehand, case number 219-5185, licensing compliance officer Timothy Williams. Page 16 of your agenda, expert on the case, building director Samuel Acosta.
Timothy Williams, Citrus County Licensed Compliance Officer, case number 219-5185, Chapter 18, Article 1, Section 18-8A. Obtain after-the-fact permits for all construction or modification of the Citrus County Code of Ordinance. Address is 10 South Lincoln Avenue, Beverly Hills, Florida, 34465. Property owner is Leona Forehand. It was good service via posting at the property and the Lecanto Government Building. I would like to authenticate the following documents and request that they admitted into evidence. Exhibit A, photos taken on my initial inspection on July 17th, 2023. Photos taken at my corrective action inspection on September 15th, 2023, and photos taken at my final inspection on December 19th, 2023. Exhibit B, a copy of the notice of violation, a copy of notice of hearing, a copy of the pre-hearing order, and a copy of the continuance letter and the posting affidavit.
Okay. You want to introduce those in evidence?
Yes, sir.
I'd like to ask you to share them with the county attorney. Is there anyone from the public who's here to, who wants to be heard on this case? All right, I see no response. All right, without objection, what's been proposed as exhibits A and B are evidence. I'm ready.
On July 17th, 2023, an inspection was conducted at 10 South Lincoln Avenue, and photos were taken regarding a complaint of a swimming pool without a permit. During inspection, I observed an above-ground swimming pool in the backyard. A notice of violation was issued for an after-the-fact permit. At my corrective action inspection on September 15th, and the final inspection on December 19th, the property remains the same and without a permit.
Is there anyone else who wants to testify on behalf of the county? I hate to make you stand there and not say anything. You're good?
All I can say is the permit would be required.
Okay. Have you had contact with the owner?
No, sir,
Okay.
not at all.
All right, what's your recommendation?
The Citrus County Code Compliance Division respectfully request that the special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected on the basis of the action of the property owners once they were advised of the violation. We would also like the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
How long does it take to get assuming it was all good, how long does it normally take to get a permit for something like this?
I'd say reasonable time frame would be 2 weeks.
Okay, and they've been on notice of this for a while, so.
Yes, sir.
I'll grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, a fine of $50 per day will be assessed. Thank you.
Thank you.
Next case, Virginia Ann Lamarty, case number 2201075, Licensing Compliance Officer Timothy Williams. Page 22 of your agenda, expert on the case, Sam Acosta, building official.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record?
For the record, my name is Wayne Walker, Civil Coastal Engineering. I'm here today with my client, Ms. Ginger Lamarty.
Okay, thank you. Now, you have previously seen that there are requirements, for being able to represent somebody. I understand the owner's here, so we can get into that. I consider you a witness, assuming she's here. But do you have a power of attorney or authorization form or anything?
I do not.
Is she willing to stand up? Ma'am, would you mind being sworn in briefly?
Not at all.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And please state your name.
Virginia Ann Lamarty.
Thank you.
Is Mr. Walker here at your request?
Yes, he is.
Okay.
Thank you.
Thank you. Please proceed.
Thank you. Timothy Williams, Citrus County License Compliance Officer. This is case number 2201075, Chapter 18, Article 1, Section 18-8A, after the fact permits for all construction or modification of the Citrus County Code of Ordinances. The address is 9311 East Ferris Court, Floral City, Florida, 34463. Property owner is Virginia Ann Lamarty, and we had good service via the signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during initial inspection on September 18th, 2023. Photos taken at my corrective action inspection on October 31st, 2023. And photos taken from my final inspection on December 19th, 2023. And a photo from the property appraiser's site from November 22 to December 22. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail return receipt indicating good service.
All right, I'd like to ask you to show those documents to Mr. Walker. And let me know if you have any objections or issues with these documents.
No objections.
Okay. Is there anyone from the public who's going to want to be heard on this case? No. Okay, without objection, what's been proposed as exhibits A and B are evidence. Please proceed.
On September 18th, 2023, an inspection was conducted at 9311 East Ferris Court, and photos were taken regarding a complaint of construction without a permit. During my inspection, I observed a boat dock being built. A notice of violation was issued for an after-the-fact permit. At my corrective action inspection on October 31st, the property remained the same. At my final inspection on December 19th, the property remains the same. I have spoken to the homeowner and the engineer about the violation and how to correct this matter.
Okay. Mr. Walker, what's going on?
Sir, we're in the process of trying to become compliant by applying for the permit. Ms. Lamarty has reached out to our firm. Unfortunately, with the workload we've got following all the storms, I have not been able to achieve the desired goal of getting a permit in place for her. However, we have got the surveys. We've got a as-built being scheduled between Christmas and New Year's, and I fully expect to have this filed with the county certainly by the end of January. We're requesting a 60-day extension just in case there's any other hiccups along the way. But if you could give us that time, I'm fairly confident we can bring this project into compliance for you with an after-the-fact permit, as long as the county accepts our stuff. But we'll definitely be in the process. So.
Big if. What's the county's recommendation?
The county code, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the action of the property owners once they were advised of the violation. We would also like the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order for reinspection.
I will find that there's a violation on the property. I'll grant 75 days to bring it into compliance. And if it's not brought into compliance, was it $50?
50.
Then $50 a day will be assessed.
Thank you, sir.
Thank you.
Thank you.
Next case on today's agenda, Pedro Reyes, case number 219-1594. Licensing Compliance Officer Keith Garner. Page 25 of your agenda. Experts on the case, Samuel Acosta, Building Official, and Land Development Director, Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, can you please state your names?
Guadalupe Reyes.
Thank you.
Pedro Reyes.
Thank you. Good morning.
Good morning.
Good morning.
Good morning.
Randall Keith Garner, Citrus County License Compliance Officer, case number 219-1594. Chapter 18, Article 1, Section 18A, obtain an after-the-fact permit for all construction or modifications of the Citrus County Code of Ordinances. Address is 1855 West Gardenia Drive, Citrus Springs. Property owner is Pedro Reyes. Good service via posting of the property at Lecanto Government Building. I would like to authenticate the following documents and request that they are admitted into evidence. Exhibit A, photos taken during initial inspection on June 16th. Photos printed from the property appraiser's website dated December 15th, 2021 and September 7th, 2022. Photos taken during my corrective action inspection of October 13th, 2023. And photos taken at my final inspection on December 19th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of my posting affidavit, and the photo of the notice of hearing posted on the property of December 6th, 2023.
Okay. Sir and ma'am, if you'd like, please take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
No, sir.
Okay. And ma'am, are you just helping?
Yeah, he's my father, honey, and I reside at the residence with
Okay,
him.
perfect. Is there any language issue or?
His English is a little off. He understands.
Okay.
But when he
Mine
talks-
is too. I mean, I don't. Thank you. Is there anyone from the public who wants to be heard on this case? All right, then without objection, what's been proposed as exhibits A and B are evidence. Go ahead.
On June 16th, an inspection was conducted at 1855 West Gardenia Drive in Citrus Springs, and photos were taken regarding a complaint about construction without a required permit. During my inspection, I observed a dog pen in the backyard and a screen room that had been converted to living space. No contact was made with the owners at that time. The owners did come in during this period to ask for additional time to get the permits required, but to no avail. My last inspection showed the room was converted back into a porch, and the dog run was still in violation. It requires a permit or would abate per the building official if the roof was removed. It would only be a structure that's not required to have a permit.
Okay, so in order to abate the alleged violations, the roof on the dog pen or animal pen would have to be removed?
Correct.
And on the porch, is there anything left to do on the porch?
I don't see anything, no.
Okay, so that's the only issue at this point is the roof.
Correct.
Christian, can we
Absolutely.
hear from our land development
We have a
director,
couple
please?
experts.
Okay. What would y'all like to say?
I had previously determined that, from the Florida Building Code perspective, if the roof was removed, it would be considered a fence. But apparently the Land Development Code has terminology that addresses dog pens.
Okay, so actually, all right, I think I understand.
Right. So the fact of a building permit may not, but a development order, you need to have a setback for dog pens from the property line. Looks like it's really close. I don't think they're meeting that setback.
Yeah, that does look close. It's not meeting the setback.
Right.
Okay, I didn't think about that. All right, so what the county's, does it understand what the county's actually saying right now?
Well, first I did understand that if we took off the roof, it wouldn't be a violation, but now setback as in being too close to the fence?
Yes, that is what the county is saying.
Okay.
Now, on your notice of violation, it doesn't say anything about that, but because the way to fix it is to get an after-the-fact permit, what they're saying is you really can't get the permit unless it complies with everything in the code, including the setback. So,
Gotcha.
so getting rid of the roof will not be sufficient. You might have heard that before, but
Right.
now you're hearing different.
Gotcha.
So have you considered that and how much time it might take to fix?
Pues tenemos que quitar porque está muy cerca del cerco. ¿Cuánto? 30 días? 30 days, just because we'd have to break everything up. And
30 days. Okay.
no, tenemos que quitarlo todo. Antes era el roofing, pero está muy cerca del cerco. Entonces tienes que tenerlo mañana, tienes que quebrarlo.
Do you know if a permit would be required to remove what's there?
No.
Is
No,
there?
It would just be a question of removing the concrete, so.
Are you sure there's not a slab?
Yes, there is a slab.
So they do need a permit just to remove, they don't need a
No,
permit to
do
remove the
not, do
concrete?
not.
Okay. Okay.
There's no, Florida Building Code to verify.
Okay. What that means is if at some point you do want to construct this thing again, you're going to have to really work with the county on figuring out how far away from the property line it is,
Okay.
among other things. All right, what's the county's recommendation?
The Citrus County License Compliance Division respectfully requests that the special master assess a fine of $100 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owner once they were advised of the violation. We would ask the special master additionally to find the respondent's responsibility to contact the License Compliance Division when the violation has been abated in order to reinspect.
Okay, I will find that the property's in violation. I'll grant you 60 days from today to abate the violation. If it's not brought into compliance as ordered, a fine of $50 per day will be assessed.
Okay.
All right, thank you.
Yes, sir. Thank you.
Buena suerte.
Okay.
Next case on today's agenda, Mark and Deborah K. Schaefer, case number 2023-207, Code Officer Cody McGuire, page 32 of your agenda. Joanna Katu, Land Development Director, expert witness on the case.
Sir? Sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Please state your name for the record.
Mark Schaefer.
Thank you, sir.
Thank you, good morning.
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 All right, Cody McGuire, Citrus County Code Compliance Officer. Case number 2023-00207, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 10194 West Sandra Street, Crystal River. Property owner is Mark Schaefer and Deborah K. Schaefer. Good service via signed certified mail return receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 8th, 2023. Photos taken during a corrective action inspection on November 13th, 2023. And photos of my final inspection conducted on December 19th, 2023. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
All right, sir, I'd like to ask you to take a look at these documents and let me know if you have any objections to them. Being evidence, at any rate.
That's not my property. That's not my property. That's not my property.
Take that as a relevance objection.
That's not my property. That's my neighbor. It's not me. It's not my property. It's not my property.
If you would direct your comments to me. So what you're saying is
Not my
that
property.
the photos in Exhibit A are not your property?
They're not my property. They're my
Okay.
neighbor's property.
Okay, all right. Please take a look at Exhibit B.
That is me.
Okay. All right, so I have an objection on the record. I'm not gonna rule on it yet because I'll want to see and we'll talk about it. Exhibit B will be admitted without objection. Is there anyone from the public who wants to be heard on this case? No. So, Mr. Schaefer, do you live at or do you own the property at 10194 West Sandra Street?
Yes, sir, I
Okay.
do.
What I'm gonna do is I'm gonna try and figure out what the county's case is, and then I'm gonna wanna hear everything you have to say about it, okay? Because I can't, it's not even worth hearing what the defense is if I don't understand the county's case.
I have photographs myself.
Okay, you'll have a chance to admit those. Right. All right, thanks. Before before you begin, let me just take a look at Exhibit A. All right. Mr. McGuire, please proceed.
Okay. On June 8th, 2023, I conducted an initial inspection and observed the shed on the vacant property. On November 13th, 2023, I conducted a corrective action inspection and noticed an additional shed was added. And as of my final inspection on December 19th, 2023, the property remains in violation and no permit has been issued, and one shed remains on the vacant property.
All right, so I've got a couple questions for you. One is, just so that I understand your case, we'll get into Exhibit A in a moment. What you're saying is when you started the inspections, there was one shed, at some point there was two, and today there's one.
Correct.
Okay. Now, you've heard the objection to what, how can you show or tell me that these photos are of the address in question?
I was able to determine that with a walking wheel from the property line that was one lot over. There's a white privacy fence that goes over, and I measured it out for that.
So you were, so you knew where one lot was, and you knew that lot based on its boundaries with a white privacy fence.
Correct.
And you were sure of that address.
Yes, sir.
And then you used a measuring wheel.
Mhm.
What were you measuring?
The distance from that to this current address.
And why were you measuring? Is it a meets and bounds legal?
It was to make sure that I was going to the right property.
I guess what I'm asking is is this property adjacent to the one with the white privacy fence?
It's on the same side of the road.
It's on the same side of the road. Are they adjacent? Meaning, are they right next to each other?
Yes.
So the property in question, 10194 West Sandra Street, according to you, is right next to, directly next to the one with the white privacy fence.
There's another lot in between.
Okay, that's what I was getting at. So what did you have to measure? Was it 90 feet, 100 feet? What was?
I don't remember the exact, the lot goes back. I don't remember the exact measurements.
Okay. And the reason why I'm asking is I'm trying to figure out how far you'd need to go with the measuring stick. And how did you determine the distance you needed to use on the measuring stick?
With the atlas on the property appraiser's website to measure the lot's frontage.
Okay. So the property appraiser card would tell us, you know, whether it was 60 feet, 90 feet, 100 feet.
Correct.
You measured it, and then you determined that the lot began, and that's where the sheds are.
Correct.
Okay, all right. All right, so Mr. Schaefer, let's turn to you. I now understand what the county is saying, and you've heard what their basis is for saying that these photos are of 10194 West Sandra Street. So what do you got?
When you get on the GPS, when you're coming down Francis or Firefly, and you go to GPS, you run right into my fence. I have a white fence that runs, I have 5 lots. And I have a white fence that I put in 2020 on my 5 lots. The GPS for my address, it tells you to turn to the left, not to the right. If you turn to the right, you see my driveway, my mailbox, my gate, my property. You turn to the left, there's a vacant lot. You run right dead into my fence. There's a vacant lot, and then there's another lot that some guy bought. He was gonna put in a little house. He moved these sheds in and all that stuff. That's his. That's not me.
Okay. And
so they got the wrong address, the wrong thing for that individual. He doesn't have an address. I don't know how he got this.
Okay. And you got notice presumably because they determined the address was
Was my
10194.
address.
They mailed it to you.
Correct.
Have you been in touch with the county about this
As
before
a
the
matter of
hearing?
fact, I talked to him on the phone once before, and he was telling me about it and said that I was in violation and I didn't have a building permit, which clearly I do have a building permit for my house on my property.
Okay.
Okay,
On
so
10194?
10194 West Sanders Street.
Yes.
I do have a building permit for my property. Okay, so evidently there's a miscommunication that he evidently thought this was mine, because when I talked to him on the phone, he said I didn't have a building permit. And I says, I
But they
clearly
still would have been
do.
able to turn up the building permit if that exists.
Correct. Sorry, Joanna Cotillion Development. They did get a permit in March of 2021. They had an electrical inspection in August of 2021. That's the end. So it is long expired. There's not an actual house permit anymore.
I had a FLIR inspection also.
Yeah,
I
that-
had a ground inspection
Mr.
also.
Schaefer, you have to, if you
I'm
would-
sorry.
Yeah.
We had COVID. My wife got cancer. She's going through chemo today while I'm here
Okay.
doing this. I am going to do a revision to the house because of the economy. I'm doing a revision. I'm building a simpler house than what I permitted. Also, the building department shredded $7,000 worth of my MEPs that I did not get in my plan from the building department from my house, that I noted the building inspector because I talked to him about it, and he says, well, I got to have drawings. And I says, according to the building department, you don't. I've been in construction in Florida for 35 years. I know better.
Well, you heard what the county said, is that you do not have a building permit because the prior one expired. I understand there's reasons.
Right.
but-
If I look on the internet, it says I do. If I pull up the website, it says I still have a permit.
Well, I'm interested
I
in
pulled
the
it up
truth.
yesterday.
I'm interested in the truth, and you have 35 years experience. So what I'm asking you is, has the permit expired? It may not be relevant.
Right, right,
Yeah,
right.
I don't-
I called them and put it on hold.
Okay.
I called the building department. I put it on hold. She says, well, you do have one more inspection, which is your ground inspection. So I'll go ahead and put it under the ground inspection. That is when Kobe called me the first time, or I called him the first time about it. So I do have a permit at that point in time. The permit is still there. I just have to do a revision on it to change the house. I have an engineer now that is drawing the plans and everything for the new MEPs for the house and the new structural.
It's your intention to have it be a valid permit?
Yes, and I will not need the building department to do the inspections because I'm gonna have the engineer with his own people do the inspections on the house as I'm building it, by law.
So what Mr. Schaefer said is that there are two vacant lots. I don't want to, maybe I misheard, but that there's two vacant lots between the one with the white fence
One
and your,
one vacant and then his, where the pictures are.
That's what I mean. I
Yeah.
mean, but you don't know who the owner is.
No, I don't know who the owner is.
Is there a map or something, I mean, that shows where the lots are?
There's a site plan and there are four lots. 3 of them are 80 feet wide and one was 55. He said 5 lots. There could be another one, but the house permit was, so Cody should have measured 80 feet over for the first lot and then another 80 for the second one.
Right.
And that's probably reasonable. I don't think he would do 200 or anything. So I have a site plan for the 4 lots. He's talked about his mailbox. That would be these lots. I don't know if you want that or not.
I mean, Mr. McGuire, did you see a mailbox at this lot?
No,
With the
sir.
sheds?
No, sir.
Okay.
Just the sheds. Well, now one shed.
I'm pretty confused.
Maybe I could, I don't know if
yeah.
it'll clarify or make it
Yeah.
worse. Okay. So, hold on, let me pull my map back up that I was looking at. Okay, so if you're standing on Sandra, that's the road in front of his residence, is that correct?
Yes.
Okay. Do you know where Firefly is that he referenced?
Firefly is one of the roads that you can come in off of, I believe it's Denellen Highway.
Okay. Do you know, is that the road you used to find this property, or do you?
I've
remember-
used it before.
Okay. So he indicated in his testimony that if you're coming down Firefly into Sandra, are my hands correct? That's how
Yep.
it goes? Okay. That if you're coming down Firefly into Sandra, you would dead end straight into his property.
You would hit the corner of his white fence, correct?
Okay. So when you did your inspection, the corner of his, is that white fence you're referencing, the white fence that's in the photos?
No, ma'am.
Okay, so when you come in for your inspection, you hit his property at the corner of Firefly and Sandra. Your photos, were they to the left or to the right of that intersection?
To the left.
Okay. So the white fence in the photo, Where is that in regards to the fence that you just testified to?
That's on another lot over.
Over to the left? We have to use,
Yes,
we
to
have to
the
use
left, I'm
directional,
sorry.
so-
Yes, everything's been going to the
Oh,
left.
to the left.
Okay, so,
I don't know whose fence that is.
okay. So you're on Sandra. Everything you're talking about is to the left of Firefly?
Yes, ma'am.
Okay. And the,
So these photos are to the left of Firefly.
Correct.
Okay.
okay. And so when you were counting off your steps, which
I walked to the left.
of which?
On Sandra,
Okay.
so from Sandra and Firefly,
Mhm.
I walked to the left.
How far?
I don't remember the footage, but Ms. Katu said 80 feet, and if I remember correctly, it was somewhere around there.
Well, here's what I'm getting confused about, because I thought what we're establishing is that Mr. Schaefer's property, you're dead end into it.
Mhm.
Then you went left. And isn't that, so his property is to the left?
His property from Firefly and Sandra would be to the right.
Okay, do you agree with that, Mr.
Yes,
Schaefer?
I go a little bit to the left,
Yeah,
and then I go all the way down to Ohio.
okay. So you're saying that you went to the left, but his property is basically to the right.
Sir?
Is that undisputed?
I didn't hear the question.
I know, sorry. So when you come down Firefly, you agree his property's to the right.
Correct.
You're saying you went to the left to take the photos.
Right. The address, the 10194, would have been to the left. His property's to the right. That's where I cited it at.
Do you understand why I have a problem right now? Because it sounds like his property's mostly to the right. Once you are Firefly and it dead ends on Sandra, his property's mostly to the right. But you testified that you've gone to the left.
Yes.
And taken the photos on the left.
Correct.
Of the lot on the lots on the left. And that you measured it out, actually. So how,
I'm sorry, we're looking at a picture that someone just handed us. Does that make it clear?
It does.
Is that where you measured?
Based on the confusion of kind of the conversation right now, we would just ask for a continuance so we can go out and measure and have
Thank you.
Or-
I'll go out there today.
information to present to the special master.
before we make Mr. Schaefer come back, let's see if there's an actual issue.
Mm-hmm. Correct. I had to pull it back up.
I'm gonna try and get as many of these people out before lunch as I can. but-
Yes, sir.
If I could have a moment. Your
Yeah.
Honor. Sir? Your Honor, at this time, the county would do a dismissal of this and investigate further and possibly issue a new NOV based off of new information.
I understand. So, Mr. Schaefer, I'm gonna dismiss this case, but, upon further investigation, if the county, sorts the record out and finds that your property does have an issue, they're gonna come back, just so you know. But this case is over. All right?
Thank you.
Thanks.
Next case on the agenda, Raydel Colazo Torres and Dan Hernandez. I tried. Code Officer Brandon Norman. Expert on the case Joanna Katu, page 35 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. Can you please state your name?
Raidel Collazo.
And the other one?
Daniel Quis Pineda.
Yulkis. Okay, thank you.
Danny.
I'm sorry, what was your name, sir?
My name is Raidel Collazo.
Okay, thank you.
Good morning.
Got it.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00087, Development Applications, Applicability, a violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code. The address is 3759 South Chicory Terrace, Inverness, Florida, 34450. Property owner listed as Torres, Raydel, Collazo, and Hernandez, Denny Lucas, Anita. I have good service via posting at the property and the Lecanto Government Building. At this time, I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on July 7th, 2023, the corrective action inspection on August 11th, 2023, and the final inspection done yesterday, December 19th, 2023, as well as aerial images from the Citrus County Property Appraiser website for December 3rd, 2021, and November 15th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, and a photo of the posted notice of hearing.
Okay. Sir, I'd like to ask you to take a look at these documents. Let me know if you have any objections to them. And is there anyone from the public who wants to be heard on this case? I don't see any response. No objections?
Good morning. And my apologies. And I'm in the building the new construction. I got the permit number.
Okay.
I'm working.
We'll get into it. I just wanted to know if you had any issues with these documents as evidence, so. Okay, without objection, exhibits A and B are evidence.
On July 7th, 2023, I conducted an initial inspection of the property for a complaint of site modification without permits. The property was found to be in violation of the above ordinance due to not having any permits issued before the removal of trees in the modification of the property. The aerial photos show that the trees were removed between December 3rd, 2021 and November 15th, 2021. I have had contact with the property owner and he has stated he has intention to develop the parcel, but he has failed to apply for any permits. That has changed as of yesterday. I was informed that a permit has been applied for, I believe.
Okay.
I have informed him about what needed to occur in order to abate the violation. As of my inspection on December 19th, 2023, the property remains in violation still. I have an expert witness, Joanna Couture.
Okay.
Just talking quickly about the permit, it's a residential lot that should be vacant. He did apply for a permit application yesterday afternoon. It had no attachments, no plans, none of the documents that are required, so it's still in the incomplete awaiting attachments, but he did get a number. So obviously that might be an intent, but nothing was submitted to review at this time.
Okay, thank you. ¿Entiendes sus palabras?
Yes, I sent tonight the
Ellos,
blueprint, every paper.
Okay. I mean, the application is incomplete. So, there's work to be done in order to let the county look at any plans for this property.
I'm saying last night.
Okay.
The blueprint, I got my phone.
Okay. Well, how much time do you need to work everything out with the county?
I don't know what is the next step.
Okay.
I sent last night. I don't know.
Okay.
But I can send today or now.
Well, yeah, but so what I'm going to do is I'm going to find that there is a violation on the property.
Yeah.
Okay.
Anything.
And what I usually need to know is how much time you need, but I don't know because it sounds like what they know you've submitted is insufficient so far.
I think in 2-3 days. I tried today
No,
again.
it won't be 2 or 3 days.
No, I tried to.
In heaven, maybe, but this. And Citrus County's close to heaven,
Yeah.
but it's not.
Yeah, I tried
It's
it.
certainly God's country, but I don't know. Yeah.
I tried yesterday with the lady, and then she said me no, send you and you home.
Okay. What is the usual amount of time this process takes, assuming there's a sufficient information in the application?
2 to 3 weeks for a house permit,
Really?
assuming everything's there.
Wow.
yeah.
Okay. Y'all are doing really well.
Yeah, we are.
It's amazing. Okay. Then I will. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 due to the irreparable damage caused by the development of the property, along with administrative costs to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible and irreparable damage caused by the violation. This amount is appropriate given the severity of the violation and the respondent's actions to this violation. It's 0.88 acres of trees that were estimated to be removed. I mean, it's a pretty large parcel. It's pretty difficult to understand what the actual impact that could have on the area. Parcels this size are required to maintain a certain amount of trees, and unfortunately, even with a permit being issued, if there was a required amount of trees to be maintained, they're no longer able to be maintained.
Okay, so you're actually answering a question I was going to have. So what you're saying is, even if he had done it the right way, there may have been a requirement that certain trees remain.
Absolutely.
Does it make sense what they're saying?
Yeah.
We just don't know because we've skipped that step essentially. So, and there's no way to really, I mean,
Could this, I'm asking this because of the amount of the fine that's being requested, but is there a way for an owner prior to the hearing to work things out with the county in a way where you don't ask for the irreparable fine?
absolutely. And based off the timeline in which that we've had a conversation, I've met with Mr. Colazo only one time when he came into the office, and I haven't heard from him at all since. And that was before I posted the actual
So
property.
theoretically, for an owner, if once the case begins or the investigation begins, they get the after-the-fact permit.
If
or-
they're showing intent to apply for a permit, I've had cases currently right now
Okay.
where, I try to work with them
Yeah.
and stretch out the process as long as possible so that they can come into compliance, because that is our goal. With this being said, I found out yesterday that a permit had been applied for. So for me as a co-compliance officer, I've seen zero intent other than the initial conversation that we've had, but I've seen no action to follow up with that conversation.
Okay. All right, I am gonna find that the property is in violation, and I am going to assess the fine, sir. And so, it's a one-time irreparable fee fine, there's no way to get out of it, it's going to be, unless it's paid, it'll end up as a lien on the property.
Thank you.
That's it. Good luck.
Next case on today's agenda, Michael Bartlett, case number 2023-905, Code Officer Alan Jonason, page 5 of your agenda.
Oh, are you ready? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your names.
Michael Bartlett.
I'm Rebecca Christensen.
Thank you.
Good morning.
Morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-00905, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, 20-60 of the Citrus County
Mr.
Code.
Jonason?
Yes, sir.
I apologize. Do you concede that grass exceeds 18 inches on the property? Or do you want to argue and contest the case?
No.
Okay. How much time do you need to fix it?
Probably 60 days.
We have no lawnmower right now, so it's a matter of a financial thing.
Okay. I thought this was going to be easy. So just so you know, because I I'm trying to get people out at a decent time. If they're willing to concede and everyone admits to the factual basis, then I'm comfortable issuing an order. Not to cut you off, I'm always happy you're here,
Yes, sir.
Mr. Jonas.
Absolutely.
But I'd like, can I see the photos?
Absolutely.
Yeah, let them if you have an issue. The reason I was hoping I wouldn't have to look.
Yeah, we know.
I don't normally do 60
We
days for
started-
grass.
I did that. The reason why I did that is because I have problems with homeless people trying to stay in there. So
Is there anyone from the public who wants to be heard on this case?
it was keeping.
I don't see any
them
response.
away. And my cousin was there, and
These are from my first inspection.
Okay.
Yeah, and the ones from yesterday.
this is across the road.
No, that's right there.
Okay.
It's
Oh,
at
okay.
CA.
Okay.
Yeah, we always try to include the house in the
Yeah.
photo so that people can see that. Hold on, let me grab that from you. One more time as you're doing that.
Yeah, no, this is, we were there like 3 days prior and
Right.
I
What
hit,
I'm
hit
concerned
something with the mower.
I just
and it
want to see the
went-
photos from the last inspection.
Oh, yeah, sure. Go ahead.
You're good.
So help, why do you need 60 days? It's financial, you're
I
saying?
need to buy a mower.
Okay.
It's been cut.
Or find someone willing to.
Well, it's
mow
been
it.
cut. It's been cut
cheaper.
since then.
Oh, it has?
Yes, sir.
You mean since the last, thank you. Since the last photos here?
Yes, sir.
Okay, so the last photos were December 7th?
No.
Oh, they're out of order? Okay.
Yeah, unfortunately, they got.
That's
put on
okay.
hold. The last photos were yesterday, 19
Gotcha, I
December.
see them.
And the front has been taken care of. It's the back is overgrown. There's some tree debris back there.
I
It needs to
see.
be taken care of.
Yeah, that's not I don't know if that's a mowing issue. It may be partially a mowing issue.
It's overgrown pretty good back
Looks
there.
like, okay.
Yes, sir.
I mean, it looks like y'all have pretty much brought the front into compliance. It's just the backyard. I mean,
And
you
honestly-
can't do that in 30 days? Well, I know you can do it in 30 days. I mean, I mean, all right, do you concede that there's a violation of the backyard?
Yes.
Yeah.
Okay. Then what I'll do is I'll find a violation and grant 45 days.
That's
Okay?
fair. That's fair.
And what's the county's recommendation on?
$50.
Okay, if it's not brought into compliance as ordered within 45 days, $50 a day fine. Okay?
Okay, and we just, now.
Keep in touch with
about-
Mr. Jonas.
Now
just give
about
me a
this
call.
address, where is this going? Cause we get mail at the house, so we
It
don't
goes
even
to
know what
whatever
this
address
is.
on the property
Yeah,
appraiser.
whatever's
So
on the
you need to go
property
to
appraiser.
property appraiser and update that address.
Okay,
Okay?
okay.
Thank you.
Thanks all.
Yep, thank you.
And just give me a call when it's completed. I'll come up and take a photo. Thank you, folks.
Thank you.
Next case on today's agenda, Thomas Aquinas Pellegrino and Hyung Pellegrino. Hope I'm pronouncing that right, sir. Code Officer Cody McGuire, case number 217-5996, page 24 your agenda. Land Development Director, expert witness on the case.
Mr. Pellegrino? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good morning.
Good morning.
Cody McGuire, Citrus County Code Compliance Officer. Case number 2175996, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. Address is 1146 North Jory Terrace, Crystal River. Property owner Pellegrino Thomas and Hoyoung and Aquinas. Good service via posting at the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on November 3rd, 2022, corrective action inspection on November 13th, 2023, and photos of my final inspection conducted on December 19th, 2023. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property and a pre-hearing order.
Sir, I'd like to ask you to take a look at these documents and let me know if you object to them being evidence, if you are contesting the case. Is there anyone from the public who wants to be heard on this case? I don't see anybody.
No. Oh, that's yours?
It's the notices and everything.
No, it's all right. I'm sorry.
Now, Mr. Pellegrino, to be clear, are you contesting the case?
No, I'm not.
Okay. Do you just want a time to bring it into compliance? Or?
Because it's land clearing, there really isn't anything I can do
Oh,
at
I
this
see.
point.
It's one of those. Okay.
But in my initial conversation that I had, and he said that I needed a permit to clear.
Hold on. Are you having evidence here? Is that evidence?
Yeah.
Okay, well, then we'll go through the full hearing. That's okay. So what I
Okay.
have to do is I have to go through the proper steps. I'll let the county present its case, and
And then
that's absolutely
okay.
right. Okay. No objections to exhibits A and B. They are evidence. Please proceed.
Okay. I conducted my initial inspection on November 3rd, 2022, and observed that the property had all the trees removed. While researching the property, I observed that there were no permits applied or issued. I've had contact with Mr. Pellegrino in which he stated he was going to use the property for a free farm for a church and a retirement home. As of my final inspection on December 19th, no permit has been applied for.
Okay. All right. So, Mr. Pellegrino, what's going on?
Okay. He's correct. I did purchase the property as for a retirement house. I was going to be building, a farm. From that farm, 80% of the produce was going to be donated to homeless shelters and stuff. I didn't know I couldn't clear my property because I went through the website looking for a permit, talking about clearing the property to develop a farm and submit this as evidence.
Is it just the code?
Yeah, I couldn't.
I mean, I agree with you. I know what it says, but it is considered site development.
Yeah, okay.
When you read it liberally.
Yeah. So I then went a little further and I found that I had to replace trees. Well, my goal was to put all these fruit trees in. So I have 32 in so far. There's an oak tree that I left there. I have 15 banana trees already on the property. I did plan on replacing the trees that I took down to develop a personal farm for myself. And then the extra produce was going to be donated to homeless shelters and stuff like that. He says I needed a permit. I didn't know I needed a permit. The thing that bothered me was that the land clearing guy that I hired, I specifically asked him, do we need a permit to clear the property for me to do a farm? And he said no. So obviously he didn't tell me the truth, but I'm the owner of the property, so I'm at fault. I admit that.
Yeah, I mean, most do get the permit, the vast majority of people are aware of it, so I'm surprised that the land clearing vendor would have said that. Sometimes in other municipalities and counties, they have it, it's like a little bit more explicit about what it is, but it is what it is, so.
Yeah,
I mean,
well,
unfortunately, you've already heard how one of these hearings went. So what I'm taking your evidence as is evidence that, it really isn't that irreparable and it's all ultimately for a good cause. Is that fair?
Yes.
Okay. Do you want to introduce that into evidence? I mean, let Mr. McGuire see it first, and then we'll see if they have any objection to it being evidence. Maybe it'll affect the recommendation.
I'll bring it over.
Did you take these photos?
Yes, I did.
When did you take them?
July of 2023, after I finished planting all the trees and preparing them for fruiting. That's just an attachment from what I printed off of the website because I couldn't find a permit saying I couldn't do it. That's why.
No objection.
Okay. I'll introduce this as a composite Exhibit C, and I'll call it mitigating evidence, you know. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a one-time fine of $2,500 along with administrative costs. This amount was selected based on the actions of the property owners once they were advised of the violations. We'd also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
The county has cut in half what its prior recommendation was on the other case, and I agree with the county's recommendation. I mean, unfortunately, there is a violation. If we're gonna be consistent in the application of the rules, I have to find that there's a
I
violation,
understand.
but the fine will be $2,500.
Okay. Can I ask a question?
Yeah.
Will this be a black mark on me when I go to file for a permit to build my
The
house when
county
I
has, to-
retire?
actually, I can't advise you. You should seek legal counsel and,
Okay.
and speak with the county. I suspect that would be illegal, but that's for you to discuss with your lawyer.
Oh, okay, so I have to pay $2,500 and,
There's gonna be a fine of $2,500.
yes,
Yeah.
I paid the $2,500 fine.
And this
then-
case is over.
Okay,
Okay?
thank you, sir.
Good luck.
Where do I pay?
Sir, you'll get something in the mail.
Oh, okay, appreciate it.
Thanks.
I think we're okay. Oh, well, would you vote? He's the boss.
I would, I'd love to call cases of folks who aren't contesting, if I can I ask?
Yeah.
Is there anyone here on a case that, they're not contesting the case on? And, sir, all right, I see you in the, what's your name, sir? Brian Dunlop. Okay, yeah, please come on up,
Come on down.
and we'll have you swear an oath. This is a Brandon Norman case. Don't lead me on, okay?
Pages 11 and 12, your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you, sir.
Now, actually, so what are these cases? We've got 3 cases?
I do have 3 cases today. I have,
sorry.
I have one case, I grabbed the wrong one. I have one case for, storage on a
sorry.
vacant parcel. I have another case for junk and debris in unlicensed and inoperable vehicles. I grabbed the
Okay.
wrong one.
I'm sorry, pages
Are you
11, 12,
aware-
and 13.
Are you aware of
I
are you
am-
aware of these 3 cases?
Yes, the vacant parcel was new to me, but I understand now,
Right.
yes.
And how much time do you need to bring the property into compliance on the storage case? Presumably to get everything off the property.
I would like to be able to comply within 90 days.
Okay. And-
I'm currently unable to access the property. I have a no contact due to a domestic disturbance that I had. So I haven't been able to be there since the 4th. Otherwise, my plans were to have had it.
That's why this one wasn't so cut and dry. I was trying to let you know.
I'm foiled again.
Sorry.
Sorry,
I do want to say that Mr. Dunlop has made every effort to
I have
communicate
no
with me.
doubt about that.
And I do believe he has every intention to come into compliance. It's just
Absolutely.
he's
Okay.
unable to at this moment.
Well, let me, how much time do you need to bring the property into compliance on the other 2 cases? Assuming
Again, maybe
it's
maybe
90?
Yeah, that would maybe a
And the
little
reason
less.
it's 90 is because will the order expire, or are you getting help?
I need help, yes, sir. I was diagnosed with a bone disease. I had bilateral hip replacements, total hip replacements, and I may have some future surgeries here shortly. So yes, it's that. But it's the biggest problem for me would be the vacant lot part that I was unaware of. But as far as getting the trash, debris in the yard and everything else, I should be
You
able
think
to
you
get
can
that.
hire people to help
Yes,
you get that done?
friends, yes.
And is that
Friends and family.
60 to 90 days? How much time do you need on that?
Yeah, that would be, anything would be grateful.
let's run, do you have concerns that 90 days isn't enough to fix the storage case?
Honestly, I do. It was
Yeah.
discovered during the course of my inspection for the junk and debris that it was actually, it appears to be one parcel, because when you get there, it looks like it's just one large parcel, it's fenced in. But once I did research on the PA, it's actually determined that there is a separate parcel with its own address there.
It's supposed to be three, honestly. That's
It's multiple
Yeah,
parcels.
yeah.
Yes, sir.
So that's where we ran into the situation where half of the junk and debris that I was there to inspect for is on that storage on a vacant parcel. And the rest of it is on the parcel with the principal structure.
Okay.
I don't know what the recourse is gonna be. I don't know what the intentions are if we're looking towards like replatting, or if we're looking towards combining those parcels into one. I'm not sure. To abate our violation, just need to move this stuff. Even if you move the stuff over to one.
I mean, will
for
it
the
be
time-
junk if it's just moved over?
Unfortunately, it will be junk.
But you don't have that case yet.
I do have it for the
I know, but you don't have it for the one with the principal structure.
I do.
Oh, you do?
I do.
So he can fix the storage case by moving everything and making the junk case worse.
And storing the things appropriately.
Okay.
And storing the things appropriately on his current property with the principal
Okay.
until he decides on how he can.
Although he can't personally do it.
Although he can't personally.
I'll make.
Okay. Well, I
I'll
mean,
move
yeah.
mountains.
I just don't want to set Mr. Dunlop up for failure.
I
that's
don't
all.
want him set up
Because he
for
has
failure
made it,
either.
once he was, because initially when I made contact, it wasn't with Mr. Dunlop, it was with a resident of the home. Once Mr. Dunlop was made aware of the situation, he contacted me immediately. He's kept me updated almost on a weekly basis as to what is going on out there.
Now, to be clear, Mr. Dunlop, you do not contest the factual basis that the county has on any of the three cases.
No, I
Okay.
do now, and I do. I just didn't understand about that empty. I've been there 10 years, and it was never. I wasn't aware.
Is
I mean,
120 days enough? To fix the storage case?
Yes, I'll make it happen.
Do you have concerns about 120 days?
I just don't know the extent of his legal situation.
I don't either, but it's also
yeah,
not.
that's true too. Oh, yeah.
I mean, but on the other hand, I don't.
But just as you said, I mean, it's not that it can't be taken care of by someone else. It's
That's
just
the
that Mr.
thing. I mean,
Dunlop
with a no
can't physically
contact
go on
order,
there.
you're still half owner of the property.
Yeah.
So you still have authority to take care of your property.
Sure.
Unless there's some unconstitutional order
I'm
out
hoping
there.
this will all go away shortly. It was kind of a
Okay. Well,
bad deal.
what's the county's recommendation?
The Citrus County Code Compliance respectfully request that the special master assess a fine of $50 per day along with administrative costs for all three cases to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find its respondent's responsibility to contact the Code Compliance Division once the violations have been abated in order to allow for reinspection. And that's just the minimum.
What I'm going to do is, what's the minimum?
The $50 a day, that's
It's
our.
the minimum you've ever
That-
recommended.
Yeah. So
I've learned the hard way a couple times in court cases that I should not tell the judge what they can and can't do or what their minimums are. But in any event, I'm joking, but I've never, I think, ordered less than 50. In any event, on your case, what's the number of the storage case?
The storage case is going to be case number 2023-00660.
On that case number, I'll find the property in violation, grant 120 days to bring it into compliance. If it's not brought into compliance, a fine of $50 per day will be assessed. On the other two cases, ending in 649 and 650, I'll find that the property is not in compliance and give 90 days in each case to bring it into compliance.
Okay.
If it's not brought into compliance as ordered, $50 per day fine in each case. Okay, they're not contingent on each other; they're independent.
Yes, I understand.
Okay, but that's it.
Great, thank you, sir.
Okay.
All right, thank you guys.
I'm sorry. Is there someone from the public? Oh, okay. You're next. Okay. Thank you, sir.
Thank you.
You're not contesting the case?
We're for public input on another case, but the defendant didn't show up. Can we?
Actually, yeah, I would like.
Yeah, okay. Next case on today's agenda, Edmund Trotter, case number 2023-819, Code Officer Julie Wilkinson, page 36 of your agenda. Expert witness on the case, Land Development Director Joanna Katu.
Yeah, if y'all would, just take a seat and I'll let you know.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
You're welcome.
Good morning.
Good morning or afternoon.
Oh, yeah.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2300819, fences, hedges, and walls, a violation of section 3150B of the Citrus County Land Development Code. The address is 5359 South Marcia Terrace, Homosassa, Florida. The property owner is Edmund Trotter. I have good service via posting the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on September 12th, 2023. Corrective action inspection on November 21st, 2023. Photos from a follow-up inspection on December 12th, 2023. Photos from my final inspection conducted on December 19, 2023, and a copy of the Land Development Code Atlas map. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the general pre-hearing order, a copy of the posting affidavit, and a copy of the notice of hearing posted on the property.
All right, are there any other people here from the public who want to be heard on this case? Okay. Thank you. All right. Without objection, what's been proposed as Exhibits A and B is evidence.
On September 12th, 2023, I conducted an initial inspection and observed a privacy fence on the property. The property owner, Mr. Trotter, refused to allow me on his property to measure the fence, but stated that his fence is in the easement. On October 30th, 2023, notice of violation was issued for fences, hedges, and walls, which is a violation of Citrus County Land Development Code. On November 21st, 2023, I conducted a corrective action inspection and met Mr. Trotter, who did not allow me access to his property to take measurements, but reaffirmed that his fence is still in the easement. On December 12th, 2023, I met with Mr. Hash of Hash Utilities, who showed me to the property monument, to the property line monuments, and I was able to take measurements for the fence being in the easement. As of my final inspection on December 19th, 2023, the property remains in violation. Land Development Director Joanna Katu is the expert on the case.
All right.
It's rural residential, mobile homes allowed. There are 7.5-foot drainage and utility easements platted in this particular site.
I mean, is it okay if it's in an easement?
No,
Okay.
no, they can vacate the easement. But otherwise, you'd have to get permission from all you public utility companies and drainage, so you need to vacate it.
Well, I mean, my understanding of a utility easement is that, I mean, you might be able to do something with it, but they'd have the right to tear it up.
We've done that in the past. The utility companies didn't even want us to do that anymore, so we stopped that.
No, I'm just saying as a legal matter.
As a legal matter, utilities need access to
I
it.
can pave over a utility easement if it's my property, but then they can rip it up and maybe even charge me for the expense.
It's also a drainage easement, so that's what comes into play too.
Okay. Yeah, I don't really, but I don't understand what the point is regardless of, I mean, what part of the section is the violation?
It's the easement, not the height. It's just the easement. 3150B.
B.
Yes.
Fences and walls may be permitted along property lines outside of required easements. Oh, I understand what it's saying. Okay, so the case is that you're only, the way that the county's reading this code section is that the county will allow fences along property lines outside of required easements, but if it's inside an easement, no go.
Yes.
Okay. I'd like to hear from the public. Who wants to speak?
One, both.
We're Kimberly and Marshall Hash.
You need to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
We do.
Thank you.
Awesome. What do y'all have to say?
We own the water utility for this neighborhood, and his fence is, yes, in the easement. And the biggest concern, the meter is in his yard, and this happens a lot. We jump a lot of fences. But he has pit bulls that have bit both of us, and so we have asked him multiple times before we got this far to please move his fence off of the easement so that we can access our equipment and he can keep his dogs.
The meter's inside the fence?
Inside the fenced-in yard of that wooden fence. We
Wow.
started with asking him to provide us with gates, and he made some makeshift gates, which he put a dog wire so tight that you cannot open. And when I got into his fenced-in yard, there is no latches on any of the inside of the gates that I could get out. So while the dogs got me, I couldn't physically get out of his yard. There's debris stacked everywhere, so I climbed over some of that debris to get out of this 8-foot fence. So we've had multiple contacts over years with him, and then it became there was a huge leak at our meter in his yard that we cannot access. So this is when we got to this point. We have to be able to get to our utility work. We try to be very understanding. People get grandfathered in, different things. He moved in after.
Yeah, I mean, if you're willing to hop the fences with pit bulls, I mean,
Yeah.
you're pretty understanding.
We try really hard, and we work before it got to this far. We try to really remedy everything we can before we come here. So I
Have
would
you ever
say,
come here before?
No, we have
18
not.
years and
never
never
had
had
to
to
get this far.
And we've tried with him for 2 years. We've tried over 2 years with him to try to remedy this because we don't want to get this far.
I hear you. I hear you. Anything else you want to say?
Is there anything else?
What's that?
Is there anything else you want to say? He's-
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin after the day you deem sufficient to abate this violation. This amount was was selected based on the actions of the property owner once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Property is found in violation. I'll grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, a fine of $400 per day will be assessed.
Thank you.
Thank you very much, sir.
concerned that if he doesn't do anything about it, just lets the fine accrue.
Well, that's actually a good point. I mean,
Seems to be a safety issue.
so it's not inherent, I guess, in my orders that the county has the authority to injunctively to take down an offending structure or something like that, right?
Not in this order.
No, I know it's definitely not, well, it's not explicit. Do I have the authority? I know I have done it in the past where if a nuisance isn't cleaned up, then I have given county authority that I don't believe it's ever used.
For public safety, we've been blessed though that
Right.
they've gotten it done.
Yeah, let's look at this real quick.
The fence needs to be relocated,
Mhm.
so that the meter is outside the fence. Unless the meter.
I'm not gonna make a finding of that. I'm gonna make a finding that it has to be out of the easement, period, but it also has to be properly permitted.
It's in the easement, it can't be. No, because the neighbors is right beside it.
If the code compliance, If the code compliance special master finds that the violation or the condition causing the violation presents a serious threat to public health, safety, or welfare, or if the violation is irreparable or reversible in nature, the county may secure, repair, or demolish the property or take any other action necessary to bring the property into compliance and charge the violator with the reasonable cost of repairs. I do find that it's a serious threat to public health and that people have already been injured. That's the evidence on the record. The vast majority of cases that come before me do not lead to injury for those exercising their rights. And therefore, I will say that if the property is not brought into compliance as ordered, I'll change the amount of time to 14 days. The fine will begin to accrue after 14 days. If it's still not brought into compliance after 21 days, the county can secure, repair, demolish the fence, or take any other action necessary to bring the property into compliance.
Thank you.
Okay, thanks.
Thank you, sir.
Next case on the day's agenda, Carvius Wolf, case numbers 2023-906 and 2023-907. Code Officer Alan Jonason, pages 41 and 42 of your agenda. Expert witness on the case, Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir.
Good afternoon.
Good afternoon.
Alan Jonason, Citrus County Code Compliance Officer, case number 202300096, accumulation of junk and debris. Case number 202300097, special requirements for all accessory structures. Addresses is 6573 and 6569 North Sourgum Terrace, Hernando, Florida. Property owner is Wolf Carvis. I have good service via signed certified mail receipt and posting in the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 27 September 2023, photos from a compliance inspection on 16 November 2023, and photos from my final inspection conducted on 19 December 2023. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing notice.
Okay, can you take a look at these documents and let me know if you have any objections to them?
Yes, no, I'm good. I understand completely.
Oh, I got you. All right. Okay, so we've got different addresses here.
Yes, sir.
Okay.
On 27 September 2023, I conducted my initial inspection and observed the property to be in violation. On 27 September 2023, a notice of violation was issued for junkyard conditions and special requirements for accessory structures, which is a violation of the ordinances mentioned earlier. On 16 November 2023, I conducted a compliance inspection and observed that the property remained in violation. I've had brief contact with the property owner, and as of my final inspection on 19 December 2023, the properties remain in violation. Expert witness, Land Development Director Joanna Coutu.
Yeah, it's about 0.22 acres. This is Coastal Lakes residential with mobile homes allowed. I have no applications. It should be vacant.
Okay. Now, on the junkyard conditions case, it looks like there's been improvement.
So.
What do you think?
So, a lot of the junk that's on the vacant has been moved behind the house.
Okay.
So it's kind of hard to see, but it is there.
Okay.
From the photos.
I mean, I see some. I just.
It almost seems like it's been moved over behind the house to try
Okay.
to get the items off of the vacant.
Okay. For the
If that makes
record,
sense.
exhibits A and B are admitted in each case. I think I understand what the county is presenting here. What's your position, sir?
Of when I first bought the property in 2016, I believed that it was sold to me as one parcel. Of it wasn't. I had to end up buying the other lot because I believed at that time that my mobile home was sitting on part of that lot. I came up here to kind of figure out what to do because I'm not too knowledgeable, I guess, to say in that area. They said that my mobile home, in fact, was not sitting on the vacant lot, so we could not merge them. I was trying to merge them so I could keep my RVs.
Oh, you tried to merge the two lots.
Right, but they said that I have to have pull permit for a permanent structure before we're able to merge the lots into one lot.
I see.
Now, as far as the junk of my old lady, her dad became homeless. He was going to help me with my house because my house is a trailer. It's kind of run down. We was just minor things, of some of that junk that we did move from the vacant lot behind the houses was building material. It's not the best building materials, but it does suffice for that aspect of. So that's where I'm at now, of trying to go through what I can use of as far as building materials to kind of help fix up my place and trying to merge my lots together so I can keep my RVs. It's just where I'm at now. Now,
Are mobile homes not allowed in these?
the RVs.
The RV is the RVs.
RVs because it's deemed a vacant lot. I talked to the people up front. They said to take it from being a vacant lot to a different category, I guess, categorization of the lot. They said it would take a matter of time that I wouldn't have been able to complete it in the time frame I had before I came here. My interest is to merge the two lots into one place.
That gets you out of one of these things.
Yeah, there's two processes. The unity of title, which is obviously what he asked about, is for structures that are being permitted, so that wouldn't work. The platting, he could possibly, unfortunately, I was looking, it's not unrecorded, it's plat, so he would have to do a replat to combine them into one. It's possible, it's not gonna be inexpensive, it's not a quick process, but it is doable.
Yeah, I mean, I'm familiar with plat process. That's
It can be expensive.
it's expensive.
Yeah.
And you never know. I mean, I don't know. You never know what's going to come up.
Right.
Well, so that leaves only a few options, really.
Remove everything.
Yeah. So, how much time would you need to do it?
Would 90 days be sufficient? 3 months time?
I mean, it's Christmas. I can work with that. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount was selected based on the actions of the property owners once they were advised of the violations. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
In each property, I will find that there's a violation. Is there anyone from the public who wants to be heard on this case? No. And so, in each case, I'll grant 90 days to abate the violation. If it's not brought into compliance as ordered, $100 per day in each case. Okay?
Yes, sir.
Good luck.
Thank you.
Next case, Dennis G. Roberts Jr. and Bonnie Jane C. Roberts. Case number 2023-762. Brandon Norman, code officer on the case, page 26 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your names.
Bonnie Jane Roberts.
Thank you. Thank you.
Junior.
Welcome.
Good afternoon. Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00762, an accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 5972 East Clovis Court in Inverness, Florida, 34452. Property owners listed as Roberts Bonnie Jane C. and Roberts and Dennis G. Jr. I have good service via posting of the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on August 28th, 2023, the corrective action inspection done on October 31st, 2023, and the final inspection done December 19th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as the photo of the posted notice of hearing.
I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
I know you've been great.
Right?
No, I've talked to him a couple of times.
Yeah, I talked to him on the phone, that was about it.
Yes, he was out of town.
Okay, well, that's bad. Oh, that's Joe's trailer.
Oh, that's from a while ago, yeah.
Yeah. We helped somebody out who didn't have a place to live. Oh, well, there's a mess.
Well, that's all gone now.
Right. Okay, I guess this was beforehand.
Yeah, all the weeds, everything, all that's been taken care of.
Oh, wait, you don't want
I
that.
mean, I got a roll of chain link fence in the driveway, but it's gotta go up.
Oh, I think we have the same thing, don't we?
That's just the notice of violation that I mailed out to you.
Okay. So we get to keep this? You
No,
get
no,
it?
you just
I just want to know if you have objections to them being evidence in this case.
No,
All right, you're
we don't
listening.
have any objections.
No.
Okay. Excuse me, ma'am, are you here for a case? You have three, okay, all right. I just didn't know if you were from the public.
She's an
or-
expert.
Yeah.
Oh, you're an expert, okay. Thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On August 28th, 2023, an initial inspection was conducted of the property for junk and debris and a lawn violation. The property was found to be in violation of both ordinances. The property remained in violation at the notice of violation corrective action inspections on October 31st, 2023, as well as the pre-hearing inspection done yesterday, December 19th, 2023, for the junk and debris. The lawn violation came into compliance. I have had contact with the property owners, and they are aware of the violation and how to come into compliance. And I do want to say, too, that I have been working pretty closely with Mr. Roberts. He's been very adamant about getting it cleaned up. He did bring the lawn into compliance. He's working towards getting the junk and debris taken care of right now. So they have been working towards compliance. I tried to stretch out as much as possible, but we were just at that point where I had to move forward. So
Okay. What do y'all have to say?
You gotta get a dumpster delivered? That's
Well,
all that's left,
the guy we had that did our property, he passed away. I have called 5 different people. They don't want to come in and weed whack or push the lawnmower. They want to come in with those big things and tear everything up. 5 of them. And some of them didn't even call back.
Well, I mean, it sounds like you have a plan. How much time do you need to implement it?
Well, figure it's Christmas, we can't have the dumpster delivered this weekend, so. Few weeks?
Okay. 30 days?
Yeah, that'd be more than enough.
You're sure?
Dumpster delivered and
Okay.
fill it up.
What's the county's recommendation?
yes, sir. The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violations as well as the respondent's actions to these violations. We would also ask that the special master find it is respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
We'll find that the property is in violation. I'll grant you 30 days from today to abate the violation. If it's not brought into compliance as ordered, a fine of $50 per day will be assessed. Okay? All right, that's it. Thank you.
Our next three cases, their failure to
Thank you.
connect to
Yes.
water connection. Do you mind if we do all three of them?
I would prefer it.
Thank you. Next case is on the day's agenda. William I. Carlton, case number 2023-795, Code Officer Brandon Norman, page 9 of your agenda.
Oh, they're all different people?
Yes.
That's fine. Let's try it.
Thank you. And
What page was that? I'm sorry.
page 9. And Lavander K. Eklund and Stacy Rich Clark, case number 2023-796, Code Officer Brandon Norman, page 14 of your agenda. And Davy K. Lovett, case number 2023-798, Code Officer Brandon Norman, page 23 of your agenda. Expert witness is Kayla Woodward of Floral City Water Association.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much.
Would you like me to present these all at the same time, sir?
Yes.
Okay. So Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00795. It's going to be for address 8155 East Gobbler Court in Floral City, Florida, 34436. The property owner is Carlton William I is his initial. For this one, I have good service via posting at the property in the Lecanto Government Building. For the next case, it's case number 2023-00796. These are all for conflict with Central Water Facilities, a violation of Chapter 42, Article 2, Section 42-39B of the Citrus County Code of Ordinances. This is for address 9165 South Starfish Avenue, Floral City, Florida, 34436. The property owner is listed as Eklund Lavander K. and Clark Stacy Rish. I have good service for this one via signed certified mail return receipt. For the last one, it's 2023-00798. Again, conflict with Central Water Facilities, violation of Chapter 42, Article 2, Section 42-39B of the Citrus County Code of Ordinances. This one's for address 11182 East Salmon Drive, Floral City, Florida, 34436. The property owner listed as Lovett Davy K. For this one, I have signed certified mail return receipt. For each of these cases, I would like to authenticate the following documents to request that they be admitted into evidence. For each case, the exhibits will be the same, but respective documents for the property owners.
Okay.
Exhibit A will be a case packet provided by the Floral City Water Association documenting the attempts to notify the property owner by certified mail or posting at the property. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed for the property that I posted, and a photo of the posted notice of hearing. For the two properties with signed certified mail return receipts, those will be in Exhibit B.
Okay. Is there anyone from the public who wants to be heard on any of these three cases? Let the record reflect there's no response. Is Mr. Carlton, Miss Eklund, Mr. Lovett, or Miss Clark here? Let the record reflect there is no response. I am gonna have to break for lunch after this. Trying to think. Hmm? I mean, I count 10 cases.
We have one that was continued, Hutchinson.
Hutchinson, okay. Shot to 9. When I time these, I mean, if we could get them done in 3 minutes per case, okay, all right.
Especially if they're Amy's.
Yes, Amy.
Amy and Cody go real fast.
All right, without objection, exhibits A and B in each of the three cases are admitted into evidence.
I do want to put on record that the tenant for 8155 East Gobbler Court was here this morning. She did express to me that she has made numerous attempts to tell her landlord about the violation. He is aware of it. And he's stating that he does not need to connect because the water at the property is better than the water that the Floral City Water Association could provide. I have informed her, while it may not be her responsibility to connect, because she's afraid she's going to get evicted, the responsibility still relies on the property owner to either provide documentation that would allow him not to connect, which would be a medical waiver from a licensed physician,
Right.
or to either connect to the central water system, regardless of what he feels about the
Yeah, I think that's an accurate statement of the
condition.
law.
I just wanted to put it on record that she was here.
Yeah.
She did want to let us know that
I
she's
appreciate
trying
that.
everything
Yeah.
to bring the property in compliance for the landlords.
Okay, thank you.
On September 27th, 2023, I received a complaint that the aforementioned properties had failed to connect to the central water system after a 365-day notice period. The properties were found to be in violation of the above ordinance. The properties remained in violation at the notice of violation corrective action inspections done on November 17th, 2023, as well as the pre-hearing inspections conducted December 19th, 2023, where I looked to see if permits had been applied for water connections, to which none had. As of today, I haven't had any contact with the properties at 9165 South Starfish or 11182 East Salmon Drive, Floral City. But I have had contact with the tenant at 8155 East Gobbler Court.
Is there anyone else who wishes to testify?
I do have an expert witness from the Floral City Water Association.
Like he said, we did speak with the tenant at Gobbler Court yesterday. For Eklund on Starfish, a family member had reached out to us. The home was in probate.
Probate.
Probate,
Gotcha.
yes, sir. And then also on the Levitt case, the resident there sent us an email stating as well that the homeowner does not want to connect.
How much does it cost to connect?
Our current residential membership fee is $2,400.
Okay. Is there a way to do that in payments?
Yes, we do offer payment plans for the compulsory connection accounts.
Okay. Is there anything else I should know?
Don't they have to run a pipe from the road to the house?
So as far as we've done in the past, once they install the meter, that's on the homeowner side. They don't necessarily, I guess, have to connect, but they do have to establish membership to be in compliance with our board of directors, as far as I'm aware.
All right, thank you. I appreciate it. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day for each case, along with the administrative cost to begin after the dates that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find it is the respondent's responsibility to contact the Code Compliance Division once the violations have been abated in order to allow for reinspection.
These are all well past the 365 days, correct?
Yes, they are, sir.
Yeah. Your recommendation was $100?
Yes, sir, for
Okay.
each case.
All right, in each case, I will find that the property is in violation. In each case, I will grant 90 days from today to come into compliance, and if the property is not brought into compliance as ordered, a fine of $100 per day will be assessed.
Thank you.
Thank you.
Next case, Sheila and Haley Marie Bohr, case number 2023-929, Code Officer Julie Wilkinson, page 6 of your agenda.
If we're trying to speed these up, all the code enforcement officers sit in the front, so
Yeah.
we don't have to wait for the long walk between cases.
I agree.
I mean, the red carpet's nice, but
Taking away our fun. Julie Wilkinson, Citrus County Code Compliance Officer, case number 23-00929. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5514 South Shalimar Point, Homosassa, Florida. Property owner is Sheila and Haley Marie Boer. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 28th, 2023, corrective action inspection on November 17th, 2023, and photos from my final inspection on December 19th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Do we need this?
I was
Okay.
getting to that
I
as
mean,
well.
without objection,
we're
what's
good.
been proposed as exhibits A and B as evidence. Is there anyone from the public who wishes to be heard on this case or any other case at all? All right, I will no longer ask if the public wants to be heard until someone from the public actually comes into the room. All right, let me take a look at these photos. What's the county's recommendation?
County's recommendation is $50 a day, along with administrative costs being after the day you deem sufficient to abate this violation. We also ask that you find that it's the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
I think it's evident from the photos, which are authenticated and admitted, that there is a violation. I will find it. I will grant 30 days from today to abate the violation, and if it's not brought into compliance as ordered, a fine of $50 per day will be assessed.
Thank you.
Thank you.
Next case, Zeta Marie Bork, case number 2023-895. Code Officer Cody McGuire, page 70 of your agenda. 7, sorry. Wow. Let's hope they don't get like that.
Oh, I'm ready.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 2023-00895, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 10710 North Autumn Oak Point. Property owner Borke Zadia Marie. Good service, signed certified mail return receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on September 25th, 2023, corrective action inspection on November 16th, 2023, and photos of my final inspection on December 19th, 2023. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a photo of the copy of the notice of violation, copy of the notice of hearing, signed certified mail return receipt, and a hearing affidavit, pre-hearing affidavit. On September 25th, 2023, I conducted an initial inspection and observed the property to be in violation. A notice of violation
All right. Without objection, what's been proposed as exhibits A and B are evidence. I will now look through exhibit A. You took these photos and Have you had contact with the owner?
I've had contact with a gentleman named Charlie.
Okay. And what did they say?
He told me on the 19th that he had totally forgot that I was coming out to do a reinspection and that it should be removed by January.
All right. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 a day along with administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask that the special master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for a reinspection.
I agree. I adopt the county's proposed findings of fact. The property is in violation. I'll grant 30 days from today to abate it and assess $50 per day fine if it's not.
Thank
Okay?
you.
Thank you.
Next case, Holly Hartley, case number 2023-844. Code Officer Brandon Norman, page 17 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00844. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. This is for address 732 Carnegie Drive, Inverness, Florida, 34450. Property owner listed as Hartley Holly. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents requested be admitted into evidence. Exhibit A will be photos taken during the initial inspection on September 21st, 2023, and the corrective action inspection on November 1st, 2023, and photos of my final inspection done yesterday, December 19th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, and a photo of the posted notice of hearing.
Exhibits A and B are admitted without objection. Thank you. Oh, yeah. I like it when it's clear.
It's about a 5-foot fence.
I think it's super evident. What's the county's recommendation?
Citrus County Code Compliance Division would like to request that the special master assess a fine of $100 per day by the date that you deem sufficient with administrative costs. This amount was selected based on the respondent's actions, given the severity of the violation as well. We also asked that the special master find it's respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
I will do that. I find that the property is in violation. I'll grant 21 days to abate the violation. If it's not brought into compliance as ordered, a fine of $100 per day.
Thank you.
Thank you.
Next case, Mark Roque and Heather and Matthew Watson, case number 2023-1087 and 2023-1115. Code Officer Julie Wilkinson, page 27 and 28 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2301115, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case number 2301087, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 3314 South Canadian Way, Homosassa, Florida. Property owner is Heather and Matthew Watson and Mark Ropsky. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on October 31st and November 1st, 2023, corrective action inspection on November 17th, and photos of my final inspection on December 19th, 2023. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit.
What's been proposed as exhibits A and B in each case are admitted without objection. All right, let's look at the overgrown case first. It does appear that as of yesterday, it's still pretty bad. And then the junkyard conditions case, I think that, oh, yeah. Is it just the car stuff or the metallic debris?
It's that stuff, and then there's like a couch or sofa, some type of furniture that's hidden back behind the overgrown vegetation.
Have you had contact with the owner?
Absolutely not.
Okay, what's the county's recommendation?
$100 per day, along with administrative costs, to begin the day after you deem sufficient to abate this violation. We also ask the special master to additionally find that it's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for inspection.
All right, in each case, I will find that the property is in violation. I will grant 30 days in each case to abate the violation, and if it's not brought into compliance as ordered, $100 per day.
Thank you.
Thanks.
Next case, Lawrence C. Smith, case number 2023-777, Code Officer Julie Wilkinson, page 33 of your agenda.
Are y'all gonna do Bartlett?
We did Bartlett.
Oh, we did Bartlett?
Yes,
Oh,
sir.
Okay, well, that explains a lot.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 23-00777, accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code Ordinances. The address is 7359 West Chesawitska Street, Homosassa, Florida. Property owner is Lawrence C. Smith. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during initial inspection on September 12, 2023, corrective action inspection on November 1st, 2023, and photos of my final inspection conducted on December 19, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the noticing of hearing posted on the property, and a copy of the posting affidavit.
Exhibits A and B are admitted without opposition. Let's take a look at this. Again, a case pretty self-evident from the photos. What's the county's recommendation?
$100 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. We'd also ask the special master additionally to find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered. Have you had contact with the owner?
No.
Okay. I'll find that the property is in violation, grant 45 days to bring the property into compliance, and if it's not brought into compliance, assess a $100 per day fine.
Thank you.
Next case, Charles Thomas, case number 2023-1090. Code Officer Amy Becker, page 34 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 23-1090, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 10068 North Glenmar Drive, Citrus Springs, Florida. The property owner is Charles Thomas. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on October 26th, 2023. Photos taken on November 7th, 2023 at my corrective action inspection. Photos taken on my final inspection December 19th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on November 13th, 2023.
Exhibits A and B will be admitted without objection. Thank you. All right, let's take a look.
On my final inspection on December 19th, the property remains in violation, tires, debris, and an appliance. I have had contact with the owner. He's requesting 30 days.
Okay, I agree, and based on the evidence, no dispute. The property's in violation. I'll grant 30 days from today to abate the violation if it's not brought into compliance as ordered. What's the county's recommendation?
$50 per day.
$50 per day it is.
Okay, let me see. Next case, Deanna L. and Brian K. Deanna Witten and Brian K. Bear. Case numbers 2023-526 and 2023-527. Code Officer Brandon Norman, page 37 and 38.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-00526, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. For case number 2023-00527, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. This is for address 7620 East Oak Forest Street, Floral City, Florida 34436. Property owner listed as Witten Diana L. I have good service via signed certified mail return receipt for both. I would like to authenticate the following documents. Request they be admitted into evidence. For both exhibits, it'll be Exhibit A, photos taken during the initial inspection of July 26, 2023. A subsequent inspection of September 5th, 2023, my corrective action inspection done on October 13th, 2023, and the final inspection done yesterday, December 19th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Okay. Without objection, what will or what is, Exhibit A and B in each case will be admitted as evidence.
I initially started this property. I gave them a verbal warning of 2 weeks. They failed to come into compliance. I've left door hangers. I've tried to make more contact with them. They're refusing to come into compliance, and as my inspections go on, the property just continues to get worse. I was given access to the adjacent property on the backside to view the backside of the property.
It is getting worse. Wow.
Yep. And it's just as if they're just refusing to come into compliance at all.
What, but have you actually made direct contact?
I spoke face
You
to
did.
face on my first inspection with the person who identified himself as the property owner. I believe he's the son of Whit and Diana L. The property's not in probate or anything.
Okay. What's the county's recommendation?
I recommend $200 a day based on the severity of the violation and their actions. Also request that they be required to contact Code Compliance Division once the violations have been abated so we can re-inspect it.
The property is in violation in each case. I will grant I'll grant 30 days from today in each case to abate the violation. If it's not brought into compliance as ordered, a fine of $200 per day.
Thank you. For each case?
Yep.
Thank you.
Last two cases, David Wilson, case numbers 2023-937 and 2023-1046. Code Officer Cody McGuire, pages 39 and 40 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 202300937, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 11807 West Bay Shore Drive, Crystal River. Property owner is David Wilson. Good service via signed certified mail return receipt and posting at the Canto Government Building. I'd like to authenticate the following documents and requested to be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 28th, 2023, corrective action inspection on October 13th, 2023, and my final inspection on December 19th, 2023. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Cody, aren't you doing both cases?
There's two different dates.
Doesn't matter. You
It doesn't
can
matter?
still- You can still
Okay.
testify to it.
And that was on case number 202300937. And then case number 202301046, unlicensed inoperable vehicle, a violation of Chapter 20, Article 5, Section 20-41 of the Citrus County Code of Ordinances. Address is 11807 West Bay Shore Drive, Crystal River, Florida. Good service via signed certified mail return receipt and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on October 13th, corrective action inspection on November 20th, and photos of my final inspection on December 19th, 2023. Exhibit B, copy of the notice of violation, copy of the notice of hearing, signed certified mail return receipt, and a pre-hearing order.
Okay. What's been proposed as exhibits A and B will be, in each case, will be admitted as evidence. I will take a look. Thank you. All right. I'll look at the unlicensed vehicle case first. Looks pretty simple. Yeah, all right. So I do find that there's a violation in that case, and in the junkyard conditions case. Yep. Have you had contact with the owner?
I have had contact with Mr. Wilson on my corrective action date, which he stated it would all be taken care of.
Okay. And what's the county's recommendation?
$100 a day for both cases, and the standard. It's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated to allow for reinspection.
All right, I adopt the county's proposed findings of fact. I will find a violation in each case. In each case, I will grant 30 days from today to abate the violation. And if it's not brought into compliance as ordered, a fine of $100 per day will be assessed. Did I say
Thank
something
you.
wrong?
No.
Is there anything else that the county wants to take up before the end of the hearing? The time is 1:04. The hearing is adjourned.